Lordship's indulgence, I beg to mention item number 70, sorry. Lordship, it was supposed to be listed. 70.
Hmm.
It was supposed to be listed for motion, but has come as orders. May it be taken up after the motions?
I don't know. It may not reach also. Today 70 matters are there. I don't know.
So,
It may not reach.
Lordship,
Just
we-
I'm saying
if Lordship takes
yesterday
up
also.
after the motions,
No, I don't think so. It may not come. May not reach also. We'll try. I'll mark it here, but it won't come.
because
Possibility of reaching the matter is very less.
because
we
my
cannot
bank account has been frozen.
No,
That's the
no,
problem.
whatever. We'll see why I have marked it.
Yes. If time permits, Lordship.
Yes.
I filed an additional affidavit in item number 17. That may kindly be called.
17. Your request is for 17? 18. 17.
Oblige, my lord.
My lord, item number 50, my lord.
50.
50, my lord. Issue of maintainability has been raised by the respondents.
Hmm.
So, my lord, I should say for 2 weeks' time, my lord.
You
I'm
need
for the-
2 weeks' time.
2 weeks' time.
You're for the respondent.
I'm for the petitioner, ma'am.
So why you need 2 weeks' time to
My lord,
file your reply?
yes, ma'am. For the question of maintainability.
Item number 50. List after 2 weeks. Okay, well,
All right.
May I please, Lordship? Lordship,
Can we
I beg to
request for
mention item number
petition side
40 item number 49, Lordship.
yes.
Lordship, I have inquired to see if CDS not received, Lordship, till today. Lordship, another matter.
Yes,
Lordship,
does C did not receive here? Are you on interim there?
interim, Lordship. Another matter, Lordship, from the.
Are you
same
on interim
FIR.
there?
Yes, Lordship.
Yes, interim be continued till next date of listing. Issue reminder for CD. When it can be listed? After view vacation. Do you date any or after view vacation? After vacation. After view vacation. List after view.
28, Lordship. 28. Another case
28.
is also there.
Another also.
From out of same FIR. Okay, 28-4.
Yes, please.
Okay.
Oblige.
May it please your lordship, my lord, because of a High Court's notification number 12 or 2025 issued on 12 February 2025, cases of the same affair should be mentioned before the same honorable single judge. So, my lord, item number 6566 today, it is notice under section 47 was called upon. If it has come, my lord, one matter of the same affair is, my lord, is pending before this court. If your lordship can call upon that matter. Same affair, same issue. If it has come, notice 65, notice. Item number 6566. Notice under section 47 was called upon.
No, we have not reached.
So then matter will be listed on Tuesday, my lord.
No, we don't, before we don't have any date. It's a motion. So how long is your petition is in bar?
My lord,
Is it charge sheeted case or not yet charge sheeted?
from 2111, charge sheeted.
Charge sheeted one. So it will
2111.
be after Bihu only. We don't have any actually. prior Bihu.
Along with this matter, my lord, let this matter be the item number 65, 66. Along with that,
Along with which matter?
65 and 66.
You're speaking of 65 and 66
66.
only.
In the 65, 66, there is a pending case of the same FIR. So it should come along with that. Madam. Item number 65, 66. The notice has not come. Item number 65, 66 of the same FIR because of the notification of the Honorable Guwahati High Court in pursuit.
What is the other number, case of the other case? number?
BA number 90525.
BA?
90525. Let this matter come along with 66, 65.
PA 905/2025 be listed along with it will be an application, so it's already. It will be after verification.
Well, because these two is not my case. These two are not my cases. When it will be called upon, then it will be listed, man. So that two are not my cases.
No, you are talking about 65 and 66.
Because of
Why?
the same affair, same because of the
So
notification.
you are not appearing on 65 and 66.
No, madam.
The way you are, I mean,
Because I am mentioning
so what can I do?
BA because of the notification nowadays, madam.
No, whatever you are talking about 65, 66,
Because of the
65,
same affair
66.
that I have to mention
Okay,
before the honorable judges, madam. I have to mention before the honorable judges because of the
Okay, that matter when it will reach, then we'll see to it.
madam.
Thank
May
you,
it
Lordship.
please your May it
Yes,
please your
Sir,
lordship. I beg to mention lordship item number 58 lordship. Here, Lordship, suspension of sentence is there, Lordship. Co-appellant case has been considered by the coordinate bench, Lordship. That bench is not available, Lordship. May I pray, Lordship, this matter be list after next week, Lordship. Because co-appellant case is already considered, suspension case is considered by the coordinate.
So
bench.
will pass the order list after 1 week. You
Next
may
week-
make a mention.
Next week, Lordship, because coordinate bench is
Date we
available.
cannot, coordinate bench will join on the next week, definitely.
Yes.
So it may be listed on next week.
Yes.
Next week, next week,
Highly.
after 1. Is it connected with 59?
59.
Both 58 and 59.
I'm appearing for 58, 59 for another council is appearing. They got that. Lordship,
59,
first.
we don't have things. Then both the matters will be there. Both. It is out of same judgment.
Yes, Lordship, out of 7.
Who is there in 58, 59? Gio Ahmed.
Ajad.
No, 58 or 59. Puna say 59. They are not here, I think, at present. কি করিব? Remind me, while calling 59. List before, list after 1 week.
Highly.
May please, your
At a
lordship.
request.
May please, your lordship. I beg to mention for listing of the matter for withdrawal matter today, because matter in this case, subject has been submitted. If today is your lordship allowed, then tomorrow.
Today, I don't know, it will be rich or I will not be.
Even then-
Otherwise, you can file.
My lord.
It may not reach. We are not in a position to take up all the matters.
If your
Lord,
lordship
after
allowed, then
filing of
tomorrow can
a
file
I
an
for
application
typo,
because
created for a typographical error in the judgment, my lord. I have filed an IA. That may kindly be checked out.
One IA has been filed. Okay, it will be called.
I'm deeply obliged.
Please, your lordship, I beg to mention item number five of daily list, lordship. Lordship.
5.
Yes,
It's a
lordship.
bail application.
Yes, lordship.
Ah.
Kindly fix it at 2 PM, lordship.
2 PM.
Yes. Highly obliged.
May please the next. Lordship, item number 56, Lordship, today's list, Lordship. Order matters, Lordship, service has completed, Lordship. Can it be, Lordship, first week of Lordship, April, Lordship, and otherwise, Lordship, the matrimonial dispute, Lordship, and maintenance, Lordship, and there.
At a request made by Mr. Adhoc, the learned counsel for the petitioner, list the matter accordingly on the first week of April. First week of April? No, first week of April, we don't have any dates. How
Otherwise,
cleverly you are saying first week of April.
Lordship,
You are very cleverly saying first week of April. We cannot fix it. After BU only it will come. We don't have any space.
But the payment in the. payment
Whatever, we
matters,
don't have any
there
space.
is
After
fixed,
BU at a
Lordship,
date.
for payment.
She's working on aguai diok na. 28. 28.
Sorry, Lordship. Date is 10 of April.
No, whatever,
Lordship.
we don't have any.
So date may not be, Lordship, and.
28 for.
After.
Immediately after BU? Okay,
Lordship.
then immediately after BU.
Lordship, Lordship. Obliged, Lordship, obliged.
May I please, your lordship, lordship? With the consent of the other side, lordship, I'd like to mention item number 36.
36.
36, lordship, this matter may take after lordship vacation, after Eid vacation.
After
Today-
vacation. You are for the petitioner, I think.
I am for the petitioner and he is for respond number.
You are for the response number. Yes, anything. to
Lordship, a
submit.
date may be fixed.
After BU.
Any date. lordship.
Any date.
Now see, these bail matters, obviously we have to fix a date, but criminal petition, we cannot fix a
Lordship,
date.
it's pending.
After BU only. List immediately after BU.
Lordship, that may be continued.
Interim is there.
Lordship.
So you are enjoying interim.
No, lordship, today.
That's why
today-
lordship,
That's why it is pending.
Because it's
Immediately
pending.
after BU vacation and both the parties are hereby asked to proceed with the hearing. At your petitioner side, at the with the consent of the other side, list immediately after BU vacation.
Interim may be continued.
Yes.
Deeply obliged.
My lord, I beg to mention this matter, this additional affidavit filed today,
Which one? Which one?
item 65. Kindly for this additional affidavit.
65.
65.
Okay, now 65, there was a submission from Mr.
Mr. Rai Chaudhary.
Rai Chaudhary, yeah.
His submission is that his matter may be tagged with this matter. Actually, this was his submission, but he is saying.
Okay. So you have filed one additional affidavit.
One
But
document-
here he has already also submitted that in this case, we need to check as to whether the 47 was issued or not. So the matter was fixed on, yes, Das, you don't have any report regarding the issuance of 47.
Sorry, my lord.
47.
My lord, item 68 perhaps, lordship, I'm appearing in. item
No, 65 and 66.
Oh, 66, yes, my lord. 66, we have also got the certified copies, my lord. As per our prayer made before, on last occasion, we made a prayer also. That in the meantime, we'll get the certified copies. That also we have already.
So they have this certified copy.
Certified
I
copy.
have also, my
I don't have any report.
The certified copy is there as per our prayer.
Okay, let the matter reach. We see.
Yes.
I have also certified.
You have filed an additional.
My lord, I have also certified copy, but to.
No, additional affidavit also you have filed.
Also, I have filed.
Additional affidavit to file. Please. Also, we are calling it the additional.
Okay.
May I please lordship, my lord?
Hmm.
A document item number in item 22, my lord. With an additional affidavit, can I brought on record, my lord?
22.
22.
Affidavit, huh?
Obliged.
May I please, your lordship, item 19, yesterday we have requested video conferencing. Kindly.
Not item 19. Item 18 or 19?
19, ma'am.
Item 19.
Yes, yes.
Okay, we'll see to it.
Lordship.
Because the man of this 47 notice they had added one, it's not clear, man. So don't you any penalty with the last order?
No, yes, sir. I can remember that, but the question was that for that we are calling for the to registry certified copy, but now
Yes.
as Mr. He is submitting that they have already obtained the certified copy. So certified copy may be legible also. I don't know. Then
It-
matter
it
will
is-
be reached.
It is, my lord.
I would like to mention item number 20, lordship. So item number 20 and item 2 are same FIR, lordship. Let matter come together, lordship.
Item 20 and
Item 2, lordship.
2 and 20.
Yes, same.
Maybe taken up, and about my item number 20 is called. Because my lord, the city has received my lord.
You need some time.
We item number 2, my lord, it was a fixed matter and it was already called for my. It is why although it is in the motion followed, my lord, we have received that case there, my lord.
So you're saying that it should be called for along with 20.
After completion of the immediately after the motion matter. So I am going to the case there, to take some time.
We will see to it.
Immediately after the motion. When the
Motion to immediately motion, there are 35 matters in the motion. 35, 36 most probably. 38 matters are there in motion. So after motion, I don't know.
20.
Let it be at least 20.
Where it is?
Let 20 reach. We
20
can
or
pick.
20, well, we'll try.
You are on 2.
I am 2.
I am 2. Okay.
May I please, the lordship? Lordship, I beg to mention for withdrawal, listing for a withdrawal, lordship. Lordship, yesterday I mentioned before the senior bench, lordship, honorable court is allowed my petition, but matter is not listed today, lordship. The matter is fixed before your lordship. That's why I mentioned here, lordship, at 2 lordship today. Withdrawal for lordship.
Let us see if it reaches.
Item 64 for withdrawal.
One.
64.
Huh? 16. Yes, 64. You want to withdraw, why?
Yes, as per the instruction of our client.
Okay. You are MS?
ADAS,
And MS ADAS,
on behalf of the DD, lordship.
appearing on behalf of Mr. Theodore. Your name is also here otherwise. On behalf of Mr. Theodore. Submitted that as by instructions of a client. She wants to withdraw this. They're allowed. Okay, it is disposed of and withdraw.
Item 1.
After some time, lordship, CD is there. Okay. Oh, it is okay. CD is there, lordship.
May it please, dear lordship.
You have received the CD.
Yes, lordship. This is a lordship intermediate quantity.
It should not be posted in the motion, so hearing was. You will come police registry. Iman who hearing like a 35, 38 hearing DD.
Lordship intermediate quantity, lordship, 56 days is today, lordship, considering the length of detention, lordship.
Yes, any other submission, Borman?
3 gram, my lord, with files, my lord. that I verified the case diary, my lord, is not mentioned, my lord. What would be the exact quantity, my lord, without the vials, my lord?
That is with vials only.
With vials.
27.43 gram, my lord. It will come intermediate, my lord. But without the vials, my lord, it is not clearly mentioned. What will be the exact?
Maybe may come also in the smaller
A
also.
small,
My lord, that is why. It will be less, my lord.
Otherwise 27.43.
My lord. And it is pending to collect the official report, my lord.
already 56 lordship, 4 days.
days custody asset. Which Mr. Borwar's submission of you made that with vials, the amount of contraband is 27.43 with vials, but there is no mention as to the quantity of the weight of the contraband without vials. However, he submitted that the FSL report is still awaited. Considering length of detention without going into the detail of the matter. To whose satisfaction this one?
Lordship SDGM Bishwanath. SDGM M Lordship Bishwanath.
SDGM M Biswanath. Okay, welcome.
Highly obliged.
Item 3.
Short query order.
Wait, please, the option. And here in this case, I was arrested on 12/11/24, and 66 is also connected, my lord. We are representing both the accused person in item 3 and 66, my lord. 66 supplementary matter.
Hmm.
That may also be taken up, my lord, together with along with item.
No, you have filed additional affidavit.
No, madam, we have not filed.
Huh?
That is another matter represented by another.
In our case, lordship directed to obtain the certified copy that we have obtained, that I have given. In the order itself, it is there in item number 66, that there is an order by your lordship.
And 65 I am representing. The issue is same, my lord.
Item number 66.
Your lordship has given liberty to us to obtain the certified copy and produce.
So this is the certified copy. These are out of same. But the notice will be, this separately the issue, in both the notices you have annexed here or what?
Already I have annexed the notice, but my learned friend says that
It is not legible in item number 66 too.
66.
That is, I have already here written there, but the question is that you are supplying here only for one accused, na?
Yes, and item.
That is for 66.
Yes.
What about A2? That's what I'm asking.
Item number 3.
Already certified copy is
Next, my lord. Page 53 is there, my lord.
In item number 3.
Yes, ma'am.
Item number 3, you have annexed. File number
Page 53, my lord.
53.
Yes, ma'am. That is the notice which has been issued to the present petitioner, madam.
Hare Krishna.
Yes, madam. Certified copy is there, madam.
One is 47, one is arrest memo.
Yes, madam.
48 is also there, no?
No, madam. There are only two documents we have annexed, madam.
47 and arrest memo.
Arrest memo, yes, madam.
Your petition is in custody since when?
My lord, since 12/11/24, and today he has completed, my lord, 136 days.
It's not charge sheeted one.
Charge sheeted, my lord.
Charge sheeted?
Yes, madam. Charge sheet is there.
What nature of case?
It is under, my lord, special act, my lord, under the narcotics, my lord. 21C, my lord.
But now you are in custody since
136 days, my lord.
So charge sheet has already been filed.
They have only come, my lord, against 47 notice, my lord. So otherwise, with certificate case, my lord, there are sufficient material collected by the IS.
130.
6 days, my lord.
Whether, my lord, the report was called for, my lord, to register, my lord, the notice was called for, whether it is received or not, my lord.
No, first we are dealing with this one, 40, sorry, 3, na?
3, yes, my
Item
lord.
three, my lord.
3, I have annexed the certificate copy.
He has annexed the certified copy. It seems that certified copy, these grounds are not there. But through registry, we have to peruse this 66.
My lord.
66 to devotion.
65 and 66.
Both 65 and 60. What was 66 to
Liberty is also there.
Oh, sorry, this is 66. Okay.
That order is there. Okay.
47 notice. And it's okay, we'll pass the order. We'll see to it.
Because all the three item, madam.
Huh?
Only madam, item number 3 or?
Here we have talking about item number 3 only.
Madam.
Now item number 60, they are saying that out of same FIR. So item number 66, office notice there, obviously.
And already I have annexed that
PNS is received
lordship.
from us.
That I
You've
have
taken
paid-
citizens. For this,
And I have enclosed that notice also in my petition, which was served to me, lordship. In page 53, that copy is 54 page, that copy is there. But as it was not certified copy, because the copy which was handed over to me by police, it will not be a certified copy. So your lordship,
Now you have
I have
mean,
given the certified
collected.
copy. Otherwise, that document I have already enclosed, I have taken the ground that your lordship will find page 54 of my petition. It is already there in the petition.
47. Now
Because the-
this now 66 also same accused. Hare Krishna.
No, 66 is Moinuddin.
It poor us.
PHKs are same.
Case number 878, lordship. My case.
No. Very happy.
The bail application. number.
878. Morning. Tell get village দিলে ইয়াত হৰে কৃষ্ণ হে দি থৈছে কি কৰিলে hey now see this one is
Hare Krishna did not is connected to item 3.
yeah this is item 3
Yes.
and the office note says stays the notice under 47 it's a Hare Krishna only can I go look কৰিলে I don't know maybe what is his name Moinuddin
Item 6.
so mili গল আছে yes is Moinuddin also here তেখেতক দেখাই দিম your petitioner is Moinuddin
Moinuddin,
in 66
lordship.
so what is your submission regarding Moinuddin
That my submission is that lordship, no grounds were communicated to him or his relatives, lordship. And in view of the recent honorable apex court judgment in Bihan Kumar's case, lordship, that is a mandatory, lordship. And in violation of constitutional rights, then the initial remand itself moved. And violation of constitutional rights will dilute that rigors of section 37 also.
this is for 66 huh?
66.
65 to the so 65 we are still here 65
65.
so see you have filed you have
Affidavit, my lord. This is the copy. And my lord, may I peruse this?
এইটো ৰচোন এক মিনিট এইটো কোনটো লগত আছে Moinuddin না Moinuddin 65 অপশন থাকে Moinuddin এইটো ও আচ্ছা ফাইল আছে এইটো তাত একেলগে ৰাখি দিম you are for 65
Hello.
65 or your 65
Yes, ma'am. This affidavit, my lord, this annexer, I have annexed this 47 notice.
here you have annexed
Yeah, next.
so why the
And not
additional
annexed in
affidavit?
the petition. So
Huh?
not annexed in the petition. So I have, my lord, filed this additional affidavit. So bring
No,
this,
petition you have not annexed it.
not annexed, ma'am.
এই অফিস নোট আছে যে 65 তাতে আউট পিটিশন জনৰ নামটো হৈছে রুবুল আলমৰ কোনো আছে নেকি তাতে অফিস নোটত চাওকচোন তিনিখন হৰে কৃষ্ণ মইনুদ্দিন রুবুল আলম সব একেলগে আছে
Same FIR.
আর ফুল আহিরিস his রুবুল আলম রুবুল আলম is also একেলগে গোটাই দিলে যে কিহৰ কাৰণে নহয় এই দুটা 47 আছে সেইটো 47 সেইটো 47 হৰকৃষ্ণটো একেলগে আনি দিলে গোটেইবিলাক 47 একেলগে লৈ আনিলে নেকি all put together Rubul Alam না
Rahul Alam.
সেটা Arrest memo আছে নাকি? নাই না? You have an arrest memo only.
I have annexed arrest memo, inspection notice and 47 notice, all three, my lord.
47 also.
Yes. Page 89, my lord.
Here you have annexed arrest memo. Then
Inspection, arrest memo,
inspection is there,
and notice.
notice. These are all certified copy.
These are
Photo
yes, my
certificate.
certificate.
Yes, Burwa, what had happened? We passed an order for calling the original from this office of the learned track court below. So, but surprisingly, all three matters, item number 2,
I have three.
item 3, 65 and 66, all are annexed together in the item number 65. Those were collected by the office. I mean, registry.
So since the PSK's number is same, my lord, so my lord, that can be considered, my lord.
No, all are same or separate, separately, this one is also.
I have also
considered.
gone through, my lord. I have also seen, my lord, that the 47 notice of my lord Moinuddin and my lord Hare Krishna Devnath has received, my lord. In item number 66.
Yes, in item number 66, apart from Moinuddin and Hare Krishna, Rubul is also received.
My lord.
In item, these are annexed in item number 65, na? All are annexed in item number 65.
So there, my lord, only ground is that, my lord, the 47 notice was not served, my lord.
Hmm.
Because they are not finding this valid because of preparing in other ground, my lord. So, my lord, that's
Most
what-
probably they are basing on that grounds, particularly on that
Yes,
ground, there are, but
yes.
as per your submission, there are sufficient materials in fact.
Other sufficient materials, my lord.
In all the three matters, charge sheet has already been filed,
Search is already filed.
already charged.
Already filed.
My lord, my once submission added, but in my case, even no materials. But 47, apart from 47, no materials against me. Nothing. Only saying that I am involved, but nothing, my lord. Nobody, even not in the name
In
of
which number? In which? 66,
65, my lord.
sorry, in 65.
Yes. Rahul Alam.
My submission will be
Obviously. কিন্তু তিনিটা আছে, তিনিটা লিপাকটত যাব। তোমাৰ পিটেড কৰি দিব পাৰি গোটেইকেইটা অৰ্ডাৰ কাৰণে। I have actually, this format is with Lipak. Those formats, so it will all go for Lipak.
My lord, my scene. My lord,
Order 65.
my
Yes,
lord, my senior PKI Chaudhary mentioned in the morning, my lord, another matter of and same, my lord, PS case, my lord. That not listed before this.
no, how can we list it now? It's not
My lord,
listed.
on Tuesday, my lord, the same FIR, same ground, my lord,
Okay.
on Tuesday, my lord.
How, mention তাতেহে কৰিব লাগিব। You have to make a mention before court number 3 only.
But-
It will be listed before us, but court number 3. For listing, you make a mention before court number 3. Court number 3.
Right.
লো বুঝেন আপনাদের।
Item 4. May I please your lordship? My lord, it is under the Assam Excise Act, my lord. My lord, the allegation is that, my lord, 37 numbers of cartoon of Arunachali liquor was found from the possession of the petitioner.
Hmm.
My lord, as per the sections, my lord, it is laws under section 303 subsection 2, 317. But out of all the sections, my lord, the only non-bailable section is 318 subsection 4. Section 318 subsection 4, which is sitting, my lord. My lord, the FIR by its contents, my lord. My lord, for, out of my limited, my lord, no, I may be wrong also, my lord, out of the FIR, I do not find the ingredients under 3138, my lord. My lord may be pleased to peruse the FIR. Annexure 1, page number 2. It's on the FIR. Annexure page 9, my lord.
Hmm.
12 days as of today, my lord. My lord. May I read, my lord?
Hmm.
Respectful submission is that today, 15/3/2025, at around 2 p.m., during Naka checking in front of Boginoti PS, along with staff, a Wagoner vehicle bearing registration number DES coming from Lokhimpur site was found carrying Onacholi liquor. The driver of the vehicle was carrying illegal liquor. Carrier Rakesh Nate, father DES, address DES, was arrested. After interrogation, came to know that those Onacholi liquor was brought illegally by doing theft from a bond, which is around 15-20 minutes from inside the Arunachal Pradesh Bandardua. Those theft illegally was brought with intention to sell in different parts of Assam and brought by not paying tax to the Assam government, my lord. This is the main allegation, my lord. And as per the seizure, my lord, 37 number cartoons were received. My lord, out of all these sections, my lord, all these sections are available in spite of 317. My lord, this is sitting. My lord, whether sitting will fall under this, my lord, because my lord, this is an FIR lost by the informant.
It is alleged to be the theft liquor which were brought.
Theft written by the informant, not lost by a particular person, my lord.
Hmm.
As per the FIR in its contents also. It, my lord, 12 days as on today, my lord. My lord,
Yes, that's.
Lordship, Lordship may kindly page number 18, Lordship.
Yes.
There are 6, Lordship.
Hmm.
The accused person is a habitual offender. He is involved in previous cases, White Gerua Muk, PSK 16 so and so, under section 379, 353, 332, 224, 511, and also Assam excise is also there. Here also Assam excise is there.
my lord, that is a
So I have objection, Lord.
Okay, we'll call for the case diary.
my lord, can it be before Bihu because 12 days?
Before we don't
My
have.
lord, immediately after Bihu.
Immediately after you, yes.
22nd.
22nd.
Obliged, my lord. Obliged.
Item 6.
That is right.
Yes.
But this is a regular bail, and the CD may be called for.
Foxo is also there.
Yes, ma'am.
Six 10 Foxo. Issue notice going to the respond number 2 through the additional police station or the today office of the
But the
registry.
thing is that my lord, he was arrested on my lord 10/1.
10/1.
Before 3 months, my lord, maybe.
10/1/25, na? 10/3. Yes, otherwise he was arrested on 10/1. But notice has to issue, notice will come, return.
Yes, my lord, because otherwise when mandatory period, my lord, after mandatory period, my lord, he may not be detained, my lord.
Okay, then we can fix it on 8. Okay. 8/4/42. You take it within 2-3 days.
Obliged.
Or let it be on 10th, then it will be much easier. 10th.
7.
Yes. Huh.
That's an intermediate quantitative right?
Yes. Since when he is in custody?
Almost 35 days. Case diary may be called for that this system. Currently may fix up 8 lotions.
No, for other reason if you stay, it will be after BU only. 35 days, na?
Okay.
35
Okay,
days.
so
40, 50.
immediately after Bihu.
He now 35 days.
Okay.
Immediately after BU, your account, he is in custody, in fact. 21, immediately on after.
Twenty-two.
Unit 22,
Sorry, 8 also, item number 8.
same.
And he is on arrested on say till date 42 days. Lordship.
42
It may be
days.
fixed on Lordship, 8 Lordship.
Same date. Or 8.
8 Lord. On
Okay, then,
18
okay, then.
in the meantime, in the
Okay. 8 weeks. 8 4.
public.
Item 9.
Yes, Borvin.
May be done. This is also a regular way charge sheeted, my lord, CD may be called, notice may be issued.
CD in sense CD along with the case record. Scan copy.
Yes.
Scan copy of the case record along with the case diary we call for issue notice. Immediately after Bihu or
Hello.
you
Hello.
immediately after, list immediately after Bihu.
Kindly, my lord, any date may be fixed, my lord.
Then if you want then it will be
Later, my lord,
Later.
maybe, my lord.
29 4.
Item 10.
May I please lordship, intermediate quantity lordship. Today is behind about 22 days lordship.
22 days.
Yes, lordship. Sitting will be called for lordship.
We are calling for the case diary. It will be on 22, 23 will not be open behind the bar. 23 4.
Eleven.
May I please, lordship? Second bail application, lordship.
Yes.
Second time, charge sheeted, lordship.
Why is the first order you have annexed?
Yes, lordship. Next are each page number 29, lordship.
Page number 20.
Behind the part since 15/10/24, lordship. More or less than 155 days, lordship.
As per you, whether victim has already been examined here? Do you have any instructions?
Yes, lordship, is already examined, 3 witnesses already examined.
Three
lordship.
witnesses
Yes,
examined.
lordship. In the meantime, CD may be called in, lordship. And
Yes, obviously we have to call for not CD case record.
Case record.
Case record along with the scan copy of the case record along with the CD. Otherwise, there has to be ground, otherwise it was rejected earlier, that's right. Case diary can immediately after koile hobo na ki korbo? You want any fixed date here? Or immediately after Bihu?
If possible, lordship, beyond, otherwise after 30 April, lordship, I may be out of station.
After 30th of
First,
April,
no, first week of May, lordship. 5th or 6th.
5th or 6th? Okay, then 5th of May.
Item 12.
Thank you, Your Worship. But this petitioner is not named in the FIR. But subsequently arrested on the ground that he has provided the vehicle to the main accused. This is the. Your Lordship, when you see, so this is on merit, and otherwise the general grounds also there, but I have got my. Your Lordship, when you see page 13 is the FIR. Page 1-3.
Page 1-3.
1-3, my. This guy is shortage my long FIR. A car was coming from West Bengal side. And in the car, they found 3 kettle. In the car itself, my lord. Plus 1.5 my lord heroin. 13 number of production, my lord. That means 1 kg, 300 grams. They found in the vehicle.
1 kg.
1 kg is commercial quantity. But they got more than 1 my lord.
13 bottles of cough syrup.
13 bottles of cough syrup they got. So if you count it, then it comes to 1.14. 3 grams, 300 grams. 1.3.
1.3.
Commercial.
Yes, it comes to commercial. Madam. Commercial is 1 kg, madam. So it is more than 1.
More than 1 kg.
It is commercial.
1 kg 300 gram.
1 kg 300.
300 grams.
100 ml per.
Yes. So just I'm coming, madam. So this vehicle is coming from West Bengal side. My house is a Gorakhpur, madam. This petitioner is, your lordship will find he is from this two persons, one driver and one co-passenger was in the vehicle. So they came. After coming them, they found the vehicle was parked in front of my house. In front of my house, vehicle was seized. It was taken. I was not there. Subsequently, I was arrested. I was not named in the FIR, arrested. So first question is, matter is not for my conscious possession, matter. And moreover, only 1 kg 300 grams, matter. 1 kg is commercial, 300 grams. And 2 persons were there in the vehicle idea, matter. Next year, let's kind of say arrest memo, matter. On 2 counts, I am coming before worship, matter. Next year, lordship will find page 20.
20.
Page 2. 20. Your lordship. This is 47, my lord. Whether it is your lordship will accept this or not. Nothing is there. It is 47. Then 40.
No, it's a 40. First one is of arrest memo, in fact.
Arrest memo, that is my lord. 40 because it was plain to the accused, my lord. Next one is my lord 48. This is written 48, but here it is nothing written, my lord. That is relation. Simply inform that so and so, my lord. Nothing more than that, my lord. Page 20, this is the only page arrest memo, and the page 21 is that part. Then, my lord, my whole case is, my lord, your lordship will find.
You got arrested on?
Arrested on, my lord, 1/2/25. 1/2/25. 55 days today. And my story is paragraph 5, my lord. Vehicle is coming from West Bengal side, madam. My house is Assam in Govipur, madam. How I can be this? I have no link at all, madam. I do not know those people, madam. So this is the basic thing, madam. One is on merit. I am not named in the FIR, so it cannot be said. Moreover, the weight is only 1.300 grams. 2 persons, they found 2 persons in the vehicle. And I was far away from that here, madam, not in that place also. And I have no place, nothing I have provided to them, madam. And second ground is, my lord, that Bihan Singh and Mihirpur case, no. And your lordship order is also there. This.
Lordship, firstly, here the commercial quantity is involved, where section 37 will attract lordship. Moreover, 61(2) is there, which is criminal conspiracy, lordship. Again, lordship, here we need the CD, lordship, to look into every aspect, lordship.
This will, order will be passed.
I have objection.
Yes.
Obliged tools.
CV is there.
A commercial quantity of heroin was recovered from one passenger in the railway station, and then based on her statement, another person was arrested in Tripura. At this stage, CD may be called for the lordship.
Is it the charge sheeted one?
No, no.
No, not yet. How many, since when he is in custody?
64 days in. yeah,
In custody.
In custody.
Yes, when can be called for?
I call lordship
After we who?
after we-
Your time.
First week of May.
First week of May or 28, 29, whatever.
20.
29 for 29 for
Much of it.
city corporation.
14.
hopelessness.
May I plead your lordship? Lordship, in this case, lordship, the accused was arrested on 21/2/2025 and 36 days in behind the bar, lordship. And the allegation is 3A Railway Property Act, lordship. In this case, lordship, I was 2 days custody and in the.
You are in 22 days.
Yes, lordship, custody. In the meantime, lordship, I disclose the other accused name, lordship. And lordship, my humble submission, lordship, I not denied my offenses, lordship. 36 days, lordship. Kindly
You are saying
consider
22 days, again 36 days.
No, lordship. 2 days I will put custody in the judicial custody, lordship, by the police, lordship. And now I am 36 days behind the bar.
You were on 2 days police remand.
Yes, lordship,
Achha.
yes. And lordship, allegation is very simple allegation, lordship. Kindly see page, seizure list, lordship, page 14.
Yes, 14.
Seizure list, lordship, very simple, lordship, 3 notes and lordship, mere loss 5 notes, lordship. This is the event. And other acquisitions from custody, lordship, page 12. And the other seizure list, lordship.
These are from other quick.
Other request, lordship, and para 4, lordship, 70 note of ERC, lordship, pen, and 5 notes. Very simple, lordship. Kindly consider my detention period, lordship. Only that's ground.
Two seizure list from you, from your the 14 number, or in both the seizure list.
Two petitioners, lordship.
Oh, here are 2 petitioners.
2 petitioners.
Achha.
Yes, lordship. And my humble submission, I'm say consider my detention period. I consider.
No, your
Correct.
1 and 2, both are same.
Yes.
Both are behind the bar since 36 days in judicial
one-
custody.
Accused number 1, 36 days.
Ah.
And accused number 2 is 32 days.
Achha. Accused number 2 also was on police remand?
Yes. Only consider my detention period. I'll cooperate with the investigation agency, lordship. That is my, I never, lordship, denied my offenses, lordship.
No. Yes.
I leave it to lordship because offense, gravity of the offense, as well as length of detention, as well as their ritual is also coming. Religious ritual, festival is also coming.
Heard Mr.
M.A. Mondal.
M.A. Mondal, the counsel for the petitioner. And also heard Mr. B.S. Flocko, the learned additional PP appearing on behalf of.
I'm appearing as a CGC lordship.
Sorry, as a?
CGC, Central Government Council.
Achha, CGC.
Representing railway.
As NF Railway, na? As learned CGC representing the NF Railway. This is an application, section so and so in connection with so and so. Next, right, is submitted by Mr. Mondal that present 2 accused petitioners are behind the bar for 36, in the judicial custody for 36 days and 32 days respectively. No, we submitted that accused petitioner number 1 and 2 are in judicial custody for 36 days and 32 days respectively. And the goods have already been seized from the possession of these 2 accused petitioners. Both the petitioners were also on police remand for 2 days. And they have already disclosed the names of the other co-accused persons and cooperated in the investigation. So considering their length of detention, these two petitions may be released on bail. Next, Mr. Lawford submitted in this regard that there are from the FIR as well as from the seizure list, it is seen that these two accused petitioners are very much involved in the alleged offense. However, considering the length of detention, the prayer may be considered.
As well as gravity of offense.
As well as the gravity of the offense. Is where from it is to the satisfaction of which court?
Special Railway Magistrate Bongaigaon.
To the satisfaction?
Yes.
Special Railway Magistrate Bongaigaon. Okay, do our petitions have granted?
Yes, Lordship. Obliged.
50.
Please, Your Lordship. The translated matter, Lordship. So, since as on today, Lordship, I am behind about 340 days, Lordship. Just because of Lordship, in seizure list page number 21, Lordship. Page 22. Just because of Lordship, total 22 numbers of scope cops here. Lordship, in connection with this, for this notification is annexed, Lordship, in page number 29. Entry 35. Methyl morphine, commonly known as codeine, and ethyl morphine, and their salts, including dianine, all dilations and preparations except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of the drug per dosage unit, and with a concentration of not more than 2.5% in undivided preparation, and which have been established in therapeutic practice. Lordship, with this cough syrup, this comes under the schedule of drugs and cosmetic rules, Lordship, which is not actually not comes under the NDPS, Lordship. And Lordship.
Now, it is a charge sheeted case.
Lordship, charge sheeted case.
Heroin also there. Heroin is also fine.
Heroin also is there. Heroin is 21 B, Lordship.
See, obviously, you are submitting the right thing, but the question is that what is the contents of this methyl or morphine in your cough syrup? That is ratio is already there, I think, submitted by the FSL expert. Whether it will come under the NDPS or not, that has to be looked into.
FSL also have the next in case. In case 36, Lordship. Result of examination based on color test in layer performance liquid chromatography technique. The presence of helium was confirmed in the exhibit so and so. And based on color test in layer chromatography and high performance liquid chromatography technique, the presence of codeine within briquette present as codeine phosphate was confirmed. No percentage was not mentioned. And
then at this stage, how can we know the percentage? Because FSL report specifies that yes, there is a codeine phosphate. That is the positive result of codeine phosphate. But what is the percentage? It's not mentioning here. And now at this stage, how can we know that what was the percentage?
I have annexed the level of the cough syrup, Lordship.
No, how can we? It's not a matter of, it's not trial, nah. We cannot go into every detail. What is the level of the cough syrup? What is this thing? It cannot be first at this stage. Obviously, you are a considerable period behind the bar. That may be one of the ground, but otherwise we are not in a position to say anything here. Because trial has already commenced?
No, Lordship, actually, since 6 months, the charges are filed, and till today, no charges are framed because of
charge is not yet framed.
Not framed.
One is absconding.
Absconding, Lordship.
Okay, then we do one thing. We'll call for the case record, scan copy of the case record that will reveal what is the stage of the case, where is the whether the absconder charge sheeted person already arrested, or what steps by the taken by the learned trial court below. That has to be seen. No, judgments are okay. There are judgments, I know, regarding the percentage of this, the quantity of codeine phosphate, etc., or methyl morphine, whatever, these are there. There should be an amount or quantity of the percentage. Then only it will come under NDPS. These are there. Judgments are also there. And the incarceration is one of the aspect. Plus, as you have submitted, 1% is still absconding. That may be also, but unless we produce any record, we are not in a position to.
Generally, the cough syrup is generally 0.2% lordship as per the level of the cough syrup lordship.
No, now see this, these will come, these are the matter of, in fact, the trial. What is the level? You can proceed everything, or you can place everything before the court. We have 2-3 grounds we have to see while granting bail. Entire materials we cannot be assessed at the time of this bail petition. We are calling for the case diary now. Sorry, scan copy of the case record and the present status of the case record.
Short date may be given because I am behind by since 340 days.
We don't have any short date. What to do? Short date is not available with us. At best, we can give after 1 week. Then, if it is listed, then it's okay. Okay, but where from it has to come? Scan copies from Dhubri. Let it be after 1 week. We don't pass. I mean, give any specific date here. Date cannot be given. If you subject that the short date, we don't have any short date. So over last 1 week, if it comes, then it will come on after 1 week. After 1 week, we just call for the scan copy of the case record along with the case diary. Why you can mention to record of a when the registry will do the needful. List accordingly after 1 week.
What
is your name?
B. Ali Sheikh. B. Ali Sheikh.
B. Ali Sheikh. Otherwise, you have submitted a good submission. Okay.
16.
May I please your lordship? Lordship, this is an NDPS matter, my lord. My lord, interestingly, my lord, in this case, my lord, the informant has filed the FIR and finding ganja seized from me 0.625 grams. Seizure made on 0.625 grams.
0.625 grams?
Yes, my lord. The seizure is made under 0.625 grams. Forwarded under column 0.625 grams. And even, my lord, nowadays in the new concept of the FIR, there used to be a history. That also 0.625 grams. Thereafter, my lord, the inventory is prepared under heading 625 grams.
625. Inventory.
Yes, my lord. Inventory is prepared under 625 grams. It is the informant who is the IO, is a police officer. He has prepared 0.625 grams, seizure 0.625, forwarded under 0.625 grams. Thereafter, the inventory is prepared under 625 grams. And what is more peculiar that I found in this case, I was arrested on 17/2. Immediately, my lord, not even within 24 hours, on the next day itself, the IO has filed a petition under 53 to be, before the Honorable Court to permit to dispose of the materials, and the Honorable Court permitted also.
But by that time, your
only one
contraband has already sent for examination.
Yes.
Otherwise, inventory is prepared.
Inventory was, my lord. But within not even 24 hours, it was made, it was done so haphazardly within on 18 itself. 52A under subsection 3 NDPS application was made, and the Honorable Court has allowed also after, no doubt after verifying, but allowed also within 1 day. I was arrested on 17/2. Next day itself on 18/2. And whatever may be the case, my lord, when the informant himself, the investigating officer himself, these are their records, and everything was prepared by them as under 0.625 grams, then the inventory, as per my humble submission, will not play a role at this stage. Even if the records are the same, will be, this is a certified copy itself. So, my lord, my submission is that I am 39 days as on today, 0.625 grams is, and my lord, if my lord requires the page numbers also, I can give over to my lord. It's under page 13, 16, 17, And even 24, it was reflected 0.625 grams, my lord, everywhere. Only the inventory deals with 625 grams, and the learned court below, while rejecting my bail application, has gone through the heading of the inventory stating 625 grams of ganja, my lord. But my submission will be that 625 grams will not play the role, since everything was written by the, even forwarded under the column 0.625. My lord, for a second, I take your lordship to page 25, the forwarding. I'll go only to the relevant, my lord, to page 25, last, my lord, fifth line, my lord, page 25, last fifth line. My lord could see cannabis 0.625 grams. Page 25, last fifth line, my lord, 0.625 grams was recovered, my lord. My lord,
Where?
my lord, page 25,
But there is difference, you see.
cannabis is 0.625 grams.
Suspected to be cannabis is detailed so and so weight is 0.625.
0.625 grams.
But subsequently in the same para,
Yes.
he has written the seized item 625.
No, my lord, 0.625. Point is there.
Oh yes, point is there.
Point is there. And my lord, that was 17. My lord, 26 was the Shivratri. Actually, that was the reason. 26 was the Shivratri. He brought this item to put it at ceiling, my lord, that he was arrested. But whatever, my lord, later on, it was converted to 625 in the inventory only. And what's surprising is that within 24 hours, within 24 hours, the petition was filed and the Honorable Court allowed also to dispose of the item. So whatever will come through this record only. Everywhere 0.625 grams. And my lord, 39 days as on today. And
Yes.
my lord, the main reason was Shivratri was there and like also he was arrested.
With my limited knowledge, lordship, it is point is there because it is written as 5 kg 0.62 grams or like that lordship. It is,
5 kg.
no, as usual lordship, the process is that 5.5 kg 0.62 grams. It is, but what I need to state,
Point one, I could not follow you. What you are saying? Point?
if it is above kg lordship, it is 5 kg 0.62 grams, 5.62 grams. It used to written like that lordship.
Yes.
So here 0 is there lordship. I think it does not much difference is there lordship. The thing is that 625 gram is there because in the seizure list is also here.
No, there is a difference. Very difference. A distinct difference because 0.625 and 625 is a vast difference. But you cannot say that 0.625 is the kilogram. How can you say?
No, lordship, I want to state here, if it is 0.6, then it will be different. 0.06. But here is written 0.625.
Yes, 0.625.
Yes, lordship. That means that this is 625 grams, lordship. It is below 1 kg, lordship.
After point, this very minimal variables.
Yes,
if it is suppose say 8.252, even 8.264 can be also written.
Lordship.
Because it is after point,
Lordship.
after the point, after this one.
Lordship.
So why I'm just not following you? How can it be 625 gram?
In the seizure list also it is clearly
0.625 gram and 625 gram is, you cannot, how can you say that 0.26 gram?
I think there is lordship, the format is like that only because they in a police lordship, according to police, I'm sitting like on that point lordship. They used to write 5 gram, 5 kg. No, I'm just talking about this.
No, if just generally they write suppose 5.25 kg. There may be. But if it is written in 5.256 kg, it's also correct.
Yes,
6 is nominal, somewhere you can.
Lordship,
Then you just if it's point after point, if it's 8.9 suppose.
Lordship.
8.9 grams suppose 6.89 gram. Then you can write as a 6.9 gram also. Because one can be here. So these are the calculations. So 0.625 and 625. I just cannot say. How can you say that?
But in a seizure list also it is written here, lordship.
Yes.
Point is not there, lordship.
Seizure list point is not there.
Not there,
My
lordship.
lord, page 17.
Page
17. My lord, may be please to bear the certified copy for a second. Page 17. My lord, may kindly see this was the way it came, my lord.
Page 17.
The certified copy, because my lord, that is Xerox, I'm sending page 17. My lord, may kindly see 0.625 is there. Page 17. It's all.
Page 17,
No,
what
my
is
lord,
page?
my lord. Seizure list that,
Not page 17.
it's not page 17, my lord, my lord, page 16. Page 16.
Yes, 0.625 gram.
That is why the Xerox,
So
that is.
I have in page 22, Lordship, I have seen page 22. It is, though it is not legible, Lordship. So I have seen page 22.
22?
Type copy, Lordship.
This is a type copy.
Lordship. I have not. Anyway, Lordship, they scattered for search it.
No, search it night.
And CD may
Because my
call
lord,
for
39 days as on today, my lord. And main reason was, my lord, the Sibrati was, he brought it to put it in the ceiling and then came back. It was 0.625 later on inventory because came back. My lord, may
Small
kindly
quantity,
consider
Lordship.
the
It
length
is
of
small quantity.
length of detention, my lord. So, my lord, this.
Suppose if 625 gram is also there, then in that
Then
case
Small,
also.
small. Lordship, yes, it is true, Lordship. 0.625. It,
But I won't say that small quantity is available. That is not the.
That is different. But here I am emphasizing because as per record 0.625 gram, my lord.
it is true.
And
It is
nothing,
small quantity, Lordship.
even later on, if the records also come, this will not go. 0.625 will not go because it was the informant, it was the IO, it was their forwarding, everywhere 0.625. My lord, we kindly consider
Heard
39.
MS as the Borba, the learned counsel for the petition. And also heard Mr. KK Das, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. First off, it is submitted by MS Borba that the present accused petitioner is behind the bar since 6/17/2025, that is 39 days. And thus the IO was sufficient opportunity to interrogate him, keeping him in custody. But it is submitted that it is very surprising that in the FIR, seizure list, forwarding report, the quantity of contraband ganja is mentioned as 0.625 gram. But surprisingly, but in the inventory, it has been mentioned as 625 gram. And the prayer for disposal of the contraband was also made immediately on 18/2/2025, and same was disposed within a 1 day. But this is submitted that this is of the contraband which was alleged to have been recovered from the possession of the accused petitioner is much lesser than a small quantity, and considering his length of detention, he may be released on bail. Next one, Mr. Das, the learned additional PP, submitted in this regard that admittedly the contraband which was recovered from the possession of the accused petitioner is small quantity, but CD will reveal the actual fact of the case as to whether the petitioner is a consumer or a drug peddler. Next one, considering the submission made by learned counsel for both sides, gravity of the offense vis-a-vis the length of detention already undergone by the accused petitioner, I find that further custodial detention may not be required for the purpose of investigation. Accordingly provided for you. From where it is pending? Where it is pending? Dibrugarh. Yes.
Forwarded to additional CGM Dibrugarh.
To the satisfaction of, but CGM, it has to be CGM,
my lord.
CGM Dibrugarh. Okay.
Obliged, my lord, highly obliged.
17.
Request was for 18. 19. Request was for 19.
May it please your
Yes.
lordship. One of reasons is under section 483 of the BNSS, your lordship. A lady is behind the birth, your lordship. One page 10 is the FIR, your lordship. Page 10 is the FIR, your lordship. Where actually what even the husband is involved. For a forwarding report also it reveals that her husband is involved. She is hiding her husband. She is concealing her husband. She is not telling the police where the husband is. Page 10 is the FIR, your lordship.
Now the present petitioner is the wife.
Wife, my lord. Husband may be involved, my lord. From the forwarding report, I'll take your lordship. First 10 is the FIR, your lordship. Lordship may kindly.
Where is the allegation against wife?
Wife, my lord, there is no allegation against the wife in the FIR, but page 15, my lord, the forwarding report relevant portion, my lord. Relevant portion, my lord. Page 15, my lord. One Bangladeshi currency note, my lord, that is not linked with this case, my lord, and on some coins were recovered. Number 2, my lord. Number 2 is during investigation, it has been learned that the arrested accused lady had been fully abated, instigated to her husband, Abdul Jalil, who is the affair named accused to commit the offense and to absconding him from arrest. The accused person being a woman having no clear of law. She have been concealing the affair named accused person Abdul Jalil at unknown location and giving time to time information to the police. And this is the allegation. Now, Lordship may kindly see that this lady, my lord, has 3 minor children, my lord. I have annexed those, my lord, page 16 with the birth certificate. Only allegation, my lord, why she will, my lord, the husband has committed something, my lord. Now, my lord, lady cannot be arrested. Page 16 is the, my lord, birth certificate of her, my lord, child, my lord, who is born in 2013. Then again, in page 17, there is another, my lord, birth certificate who is born in 2010, my lord, minor. And now page 18, my lord, 2.5 years, my lord, child, my lord, page 18, my lord, and the child, my lord, the child, my lord, he is also with her mother, my lord. That will be reflected from page 22. The child is also inside the jail, my lord. Page 22, my lord. Page 22, my lord. Lordship has seen, my lord. The last second paragraph, my lord. Page 22. The 3 minor children are left at mercy, my lord. Nobody to look after them. And page 20, however, the fact, page 22, Lordship has got in, my lord. The last second paragraph, however, the fact that the accused has a 2-year-old baby with her in jail needs attention. The superintendent jail Nagav, allowed Lordship, and today morning also I have filed an additional affidavit, my lord. It maybe it is in the record, my lord.
Yes, it has come.
Yes, my lord. Here, my lord, Lordship may kindly directly turn to my lord, page 29, my lord. 29, my lord. This is the notice under section 47, my lord. Right, copy, my lord. So
So, my lady, my lord, she is nowhere involved. Only that she is hiding her husband somewhere, not telling the police the whereabouts of her husband, my lord. That cannot be alleged. She is more than 25, 26 days in custody, my lord. Page 29 and 32 is the notice under section 48, my lord. So, here, my lord, no grounds of arrest has been assigned. And that apart, my lord, the 3 minor children, my lord, the festival is there, my lord, and 1 baby is inside her, with her, my lord. So, my lord, and allegation is that, my lord, she is concealing her husband. How can she conceal, my lord? Well, husband has committed something, went somewhere, my lord. And police has got sufficient time for interrogation, my lord. 26 days. You are arrested on, my lord, 2, 3, my lord, 3 she was forwarded. So, my lord, sufficient time, and my lord, the lady, my lord, only ground, my lord, that's it. She is concealing her husband somewhere, not telling the police, my lord. Now, investigate, she is in jail, my lord. So, further detention may not be required, my lord. And moreover, my lord, notice was served without any, my lord, grounds of arrest, my lord. And regarding the children, my lord, festival, there are 2 children outside, minor children, and 1 with the mother in jail.
Yes, please.
Lord, what of the section attracted here is, it is stated here, Lordship, Arms Act is also there.
Arms Act.
25 1A and 23, it is, though it is not specific allegation is there regarding that in regard to the petitioner, but section 61 2 is there, criminal conspiracy is there, Lordship. And moreover, in page 15, point 2, there are abatement and instigation to her husband is there, Lordship. Moreover, harboring of offense is also there, harboring offender, Lordship. So, without looking the CD, it is difficult, Lordship. On regarding 47, I have nothing to say because it is related to law, Lordship.
And 3 minor children, my lord. And harboring, lordship knows the bailable section, my lord.
Otherwise, I leave it to Lordship.
Why section 25(1)(a) is
No,
also there?
husband, against the husband, not against her, my lord. Her allegation is that she is harboring her husband, my lord. She is not concealing her husband somewhere, not telling the police, my lord. But that is also 26 days in custody, my lord. Police has got sufficient time to interrogate her, my lord. Now, my lord, regarding her, my lord, investigate, and her baby is also inside, my lord. Festival is there. 2 minor children outside, my lord. Father absconding somewhere, my lord, and mother inside the jail, my lord.
In my humble submission, I only wanted to point 2 things, Lordship. One is 61 is there, Lordship, that is criminal conspiracy. And second is, Lordship, in her position, some 1 gold coin from position and Bangladesh currency note is also
1
there.
note, my lord. It is from her house, my lord. From her house. 1 note, my lord.
Otherwise, I'll leave it to Lordship.
Heard Mr. S.M. Abdullah P, the learned counsel for the petition. And also heard Mr. P.K. Das, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Next para, it is submitted by Mr. Abdullah that the present accused petitioner is no way related in the alleged offense, and nothing has been brought against her in the FIR. However, it is the only allegation brought against her that she harboring her husband or concealing him, and concealing him to avoid the police arrest. That apart, there is no other allegation against the present accused petition. She is behind the bar since last 3/3/2025 and does the IO for sufficient time for her custodial interrogation. Mr. Abdullah further submitted that she has 3 minor children, out of which 1 is 2.5-year-old child who is along with her inside the jail premises. Another 2 minor children are outside the jail, in his house, in her house, and there is none to look after their minor child. He further submitted, next para, he further submitted that in the notice issued against her under section 47 and 48 BNSS also does not reveal any ground of arrest, which is mandatorily required to be followed. And as per the ratio laid down by Honorable Apex Court in case of Probir Purkaister and Bihan Kumar. He further submitted that she is still ready and willing to cooperate the IO in further investigation of this case. Next para. Mr. Das, the learned additional PP submitted in this regard that in the FIR there may not be any ingredients, may not be any allegation against the present petitioner. However, the present petitioner is also involved as a conspirator, and the section is, and the case is also registered under section 25(1) small a and 27 of the Arms Act, and hence considering the gravity of the offense, the petitioner, the perusal of the case diary is necessary, and he accordingly raised objection in allowing the present petitioner on bail. Next one, hearing the submission made by learned counsel for both sides, considering the length of detention, vis-a-vis considering the non-compliant fact that there is a total non-compliance of section 47 and 48, which are mandatorily required to be followed. And in view of this and other aspects of the considering other aspects of the case, I find it a fit case to allow the petitioner to go on bail. To the
SDGM Koliabor M Noga. SDGM Koliabor M.
SDGM M, record M Divo, Koliabor, Noga, to the satisfaction.
My lordship says NDPS, it is arms act, no.
No, he's, and I have said NDPS. Oh, sorry. Arms Act. I have Arms Act.
Oblige, your lord.
Yes. Let's go to pass me that. Okay, then one more supply.
18.
Wait, please, your lordship. Regular bail application.
Yes.
54 days in custody, my lord. Under Arms Act, my lord, 25(1) AA of the Arms Act, my lord. Lordship will find my forwarding report at page 13, my lord.
13.
Page 13, my lord. May I read, my lord? Brief of the case. Brief of the case is that on 7/1/25 at around 12:32 p.m., based on secret information from Crime Unit SP OK Sujai regarding keeping of illegal arms in the house of one Krishna Ram of so-and-so place, self along with the staff of Lamding PS, comprising so-and-so, conducted a search operation in the house of Krishna Ram of so-and-so place. And during the search, Krishna Ram was found, and on search, the following items could be recovered, which kept concealed in his bathroom, and accordingly seized. 3 items were seized, madam. 1 black color country-made pistol made by iron, 1 toy pistol with built-in lighter, and 1 golden color metallic article weighing 237 grams. After local inquiry and examination of Krishna Ram, it is learned that the brother of Krishna Ram, namely Ramji Ram, brought the suspected country-made pistol with the other seized article for making a trap against his brother Krishna Ram due to property-related conflict with his brother. Later, the accused Krishna Ram was apprehended, and from his statement, it is learned that he has brought the seized items from one Bolo Rai. Accordingly, accused Bolo Rai was also apprehended, who is found to be a perpetrator of the case. During interrogation, both Ramji Ram and Bolo Rai have confessed that keeping the seized articles in the house of Krishna Ram by making a trap so that police could arrest Krishna Ram for concealing suspected country-made pistol with the other seized articles. So, Krishna Ram's brother, Ramji Ram, and Bolo Rai, they procured this and tried to falsely implicate Krishna Ram. So, these Bolo Rai and Ramji Rai Ram were arrested. Now, I was arrested because, next page, round 2. The earlier arrestee, Ramji Rao and Bolo Rai, have confessed in their interrogational statements that the below named accused person, namely Altaf Hussain, have supplied the country-made pistol along with the imitation firearm as well as the fake gold to accuse Ramji Rai for laying a trap. So I am the supplier, my lord. I supplied the fake. One is fake gold and one is fake iron, but one is a country-made pistol. So case has been registered under 25(1) AA, capital A, my lord, of the Arms Act. At this is difficult to say whether this is true or not, but assuming this is true also, I am in custody for 54 days. Otherwise, my lord, I wait for case diary, my lord, but if case diary is for my lord, this will around my detention period go to around 80 days, my lord. It will be difficult to get this case listed before due, my lord. So 54 days, if your lordship is inclined to consider that length of detention, my lord.
Is it 60 days offense, I think?
No, 90 days.
90 days
90
offense. Oh, sorry, 11A.
11AA. Right. Only on length of detention, and offense otherwise is laid out.
Unchecked is their lordship, and he is also supplier lordship.
I have to see, I think, because diary is required.
This will most likely come out to be true also, my lord. I'm not very unlikely that this is not true, my lord. But only thing is that my length of detention it can be considered. Otherwise, it will after Bihu, it will be like almost 80 days.
10th can be given otherwise.
10th, if your lordship can fix it on 10th, my lord.
We try 10th. Pariboli in both cases. 10th. What is it? Both 7th and 10th. 11 রাখেও জানা মানে বেসিক্যালি সম্ভব জানা তবে রাখা একটা 11 to 9 can be 11 but 10 what is the difficulty? One VC is there. 7. Otherwise we have fixed less numbers of cases on 10th, I think. 10 more cases. Fixed matters. 14. Babre. 8 or 9 you are saying? 9 can. Yes. 9.
9. I'm deeply of that.
City call 41 9. Now we see request to link detail.
I'm already there.
Mr. Just for 5 minutes. Just I'll take a break. Okay.
Stuck in between, lordship. I'm approaching Gwalpara, lordship.
Okay. Yes.
Lordship, lordship.
Okay, yes.
Lordship, lordship, kindly peruse straight to come to page 11, lordship, the FIR. The sorry state of affair in this case is that the lordship, the informant has projected her 5 years old daughter to meet certain grievances or enmity with the present petitioner, lordship. In fact, the present petitioner was introduced to the family of the present informant by one Khonindra Bhuiya, lordship. On 17/3, lordship, they, as per my instruction, though there is no confirmed instruction, lordship, that's why I have not brought in all this in my petition, lordship. On 17/3, the Khonindra Bhuiya, along with Khonindra Bhuiya, the present petitioner has gave some social visit to the house of the present informant, lordship. And the husband of the present informant, under the impression of liquor, got some altercation with the present petitioner, lordship. And subsequently, in order to meet the rivalry, this false allegation has been made, lordship. And the allegation is made that the present petitioner has touched the private part of the 5 years old daughter of the informant, lordship. And accordingly, 75(2) and POCSO 12 is added, lordship. But in on the date of alleged occurrence, lordship, on 17/3, he is stated to be caught by the neighbors of the informant, and he was handed over to police. He was produced before the trial court special judge Bishwanath on 18/3, lordship. From the date of arrest, he is behind the bar, lordship. For the as on today, 12 days, lordship. Lordship, on the face of the FIR, lordship, the entire allegation appears to be very totally false and concocted, lordship. The allegation is made that the present petitioner, in absence, while no one present in the house of the informant, he allegedly touched the private part of the 5 years old daughter of the informant. But the second part of the allegation is that coincidentally the mother-in-law of the informant came there and she witnessed it, and thereafter the arrest follows, lordship. The entire allegation is concocted, Lordship. The petitioner is an ex-serviceman, Lordship. He is having some medical condition also. He is having liver ailments since the month of November 2024. He is under treatment, Lordship. And he from the on the date of production, Lordship, he has been sent to judicial custody. The next date of production is on 29/3, Lordship. So the as because he is sent to judicial custody, Lordship, entire the investigation is perhaps complete against him, Lordship. He is the sole accused. He is having the medical condition also, Lordship. We have annexed the medical certificate at page 18, Annex 4, Lordship, which indicates that he is having some liver ailments, Lordship. So if he is not getting the proper care inside the jail, so his health condition may deteriorate, Lordship. That's why, Lordship, and both the sections, the punishment is up to 3 years, Lordship. So as on today, he is in 12 days, Lordship, from the date of arrest, Lordship. That's why I'm humbly praying on the solely on the ground of medical condition of the accused and he being an ex-serviceman, Lordship, and nothing happened at such, Lordship. The entire allegation in the FIR appears to be very concocted and tricky, Lordship.
Yes, does.
Firstly, this is a POXO case. Moreover, secondly, if you look into the FIR, Lordship, it is true, Lordship. There is stated that while no other person was present in the house, in the meantime, Lordship, that means it may also happen that he has done something, Lordship. Then in the meantime, at that time, the person, mother-in-law was not there. But after some time, he came. But for that, Lordship, we need to look into the CD, Lordship.
Issue notices, there has to be issue.
Issue notice also need to be issued.
Lordship, only thing that 12 days behind the bar, Lordship, judicial custody. So there appears to be no scope of tampering the witnesses and hampering the investigation also, Lordship. He's being a ex-service.
But it is now the as per yes,
Lordship. Lordship.
We have to send the notice.
Yes, Lordship. But I humbly pray to fix the matter immediately before the vacations, Lordship. On the last day, on 11, Lordship.
No, 11 we are not fixing. I'm going somewhere out.
Lordship, then on 8 or 9, Lordship. Then because the person is
unnecessary. Matters are there. It will not be possible.
Lordship, kindly, Lordship, the person is unnecessary.
Maybe after vacation only.
Lordship, I make a humble prayer, Lordship, before the vacation, Lordship. On 9th or 10th, Lordship, any date.
Day 9. We're fixing it on 23/4.
No, Lordship, kindly before the vacation, Lordship.
No, we don't have any date before vacation.
Considering the length of detention, then it is a 60 days offense, Lordship. The both the sections. So maybe on the last date, Lordship, 11th of April. I humbly pray, Lordship.
11
I humbly pray. Or 9 or 10, Lordship.
10.
I humbly pray, Lordship.
10 to 9. 10 is the problem. Possible নহয় না আমার
I humbly pray, Lordship.
pray করার কথাই নহয় কেনেকে রাখি
It is from Biswanath Sarini only, Lordship.
21st, if not 23, 21st. 21st 4, 21/4. Issue notice to the respondent number 2 through jurisdiction police station routed to the office of the registry and the public prosecutor. List accordingly also call for the CD, CDB call for list accordingly on 21/4/2020. Okay.
I'm obliged.
I take your lordship indulgence to mention only one thing. At this stage, I'm very sorry, but because I do not know, because it has come, my item number is 61 euro, lordship. That is for motion. I thought that it will be just after motions and it will come, but the system is quite different. So it will
no motions are still going on.
Oh,
we are still having the motion, and obviously your matter is, if it is in motion column, we'll call it on motion column only. It will be column.
Then can I I'll take your lordship indulgence to sing. Just before recess, whether it can be taken. If your lordship allow me. No, because already I have.
Oh, your matter is not in motion column. Your matter is in order column only. It will be taken up after motion.
that it is for motion. I thought like that.
No,
I'm sorry.
it is an order column, not a
Then-
motion column.
It is for order. Yes, that also I told him that it should come actually for orders. Then I said, no, it has come for motion. I'm not see.
No, it is an order column, in fact. So
That-
motions, we have to complete it first, the motions column, then it will come. Obviously, in the order column will come up, but after the admission. But
After.
yes,
Then I'm very sorry to give so much troubles to the Honorable Court because we have to treat for so many cases. Then can it be fixed, Your Lordship? I am on 10th April. Can it be fixed? Because I have one thing my junior told me that it has not been served, nothing has come. Although we have taken steps within the limited time we have taken. So can it become on 10th of April?
no, as per your information, the notices is not yet served.
It's
61.
because
is served.
nothing has come.
61 is served. Just we are speaking it off. Service report is still awaited for respond number 2. Have you taken steps? Oh, you have taken steps, no?
I have taken steps. within the
You have
time,
taken
yes.
steps, so service is
3rd
still
of
awaited.
March, yes. Registered
We can do one thing, it can be listed after Bihu. We pass the order immediately now only.
after
Because service of notice is still awaited, in fact.
But as because there was no stay orders and others, then it will be whether my client
How
will
can we
suffer.
adjust
Yes,
all
that
these
cannot be
cases? It
done.
cannot
Yes,
be,
that is also true, Your Lordship. But it is for invoking the inherent jurisdiction of the Honorable Court because very much injustice apparently was done to the party and he has suffered a lot, Your Lordship. That's why whether it can be
Before Bihu is not possible.
Before Bihu not
And
possible.
your this things service is also awaited, I think.
Everything, yes.
It's still awaited. Even
Before
if it is
Bihu,
listed.
Your Lordship cannot, no?
Huh?
Before Bihu,
No,
there is no possibility.
not possible, not possible.
Then after
Let it be immediately after Bihu, 21st, and we can fix it until 22nd. 22nd of April, we are fixing immediately after Bihu. Prior Bihu, we don't have any dates.
Then
CD next
then
hard,
it will be better.
hard. MS K Deka, the learned counsel for the petition. And also hard Mr. K. Kedal, the learned additional PP, appearing on behalf of state respondent.
Yes, it is
Office note dated
Why, because
25/3/2025. It is seen that the service is still awaited for respond number 2. Let the service be awaited till next date of listing. Scan copy was also called for here. No. Scan copy of the LCRB also called for. This of registry will do the needful. List the matter accordingly on 22nd of April 2025. Okay, well listed.
Okay, I object.
Item 20 along with item 2.
Make feasible. My lord.
Item number 19. In metropolitan. PC2.
Yes, 21 for
21. 2 is along with 20.
My lord, make feasible. My lord, before my learned friend start, my lord, I beg to point out one thing, my lord. The case has been registered, my lord, under the sections of DNS, my lord, then UAPA, my lord, along with the Wildlife Protection Act, my lord.
Only
So, my lord-
conspiracy, my lord, only conspiracy, nothing has been.
So as far as my lord, Wildlife Protection Act is concerned, my lord, there are special PPF, my lord, only there, my lord. So I request them to appear, my lord, in this case, my lord. Let the matter will be taken up and 2 or up, my lord, some other day. my lord.
But special PP wildlife is not a party, I think, na?
No, my lord,
The
they
only-
have
only-
not made party, my lord. They have not made party, my lord.
They are not made party.
The case is registered under the Wildlife Act, my lord, then they are supposed to appear, my lord.
So now what to do? Simple verbal communication will do, or they should be made party?
I inform my lord. Since my lord, the copies are already with us, my lord. I inform my lord, so fixes another date, my lord. On Tuesday, my lord. So in the name of the Wildlife Council. But I want to come out with something.
Yes, then what to do? At two, if it is fixed at two also, they are not supplied with the copy.
Yes, but
So
we
may
need
not
to go
be
through a city also, ma'am. That is a
Go to the case there, that's the problem.
so immediately after reopening of this.
immediately after reopening.
Right.
And otherwise we can directly register to name, reflect the name of
Yes, my lord.
special PP wildlife.
You will inform also at the same time, my lord.
Yes,
I
he
also
will.
inform my lord, but name has to be shown, my lord. Mr. B. Sharma, my lord.
Huh?
Second,
Mr. B. Sharma. B. Sharma is dealing with.
My lord.
second or third, ma'am. Second or third April, ma'am.
Third April.
No, we don't have any dates. Second, third, we don't have. I mean, was everyone is asking for
No, I don't
PUB.
know.
We are flourishing with bid. Today also more than 70 matters have been fixed.
Of course, ma'am.
So it will be, most of the matters will be remain unheard. But that is the position what to do. Second, third, too, it may not be possible. I don't think so. Saxon কি করি ওইটা উপায় নাকি হচ্ছে we are helpless in that. Huh? Seven, you have fixed more, lot more up cases. This most probably we are fixing less more matters on 7th. Won't be covered up.
I think it will both might be possible, ma'am.
What will be possible? No. Nine. 7, how many now? 7. Fix 9. 7. Mr. Mukhtar, you are appearing on item number 2 also?
Only two, ma'am. 20
Only
he is
2.
appearing, ma'am.
20 you are appearing. Okay. 2. Which na lage? Black 2 is it? Mr. S. Mukhtar is appearing. It is submitted by Mr. R.J. Burwa, the learned additional PP, that the case is also registered under 51 Wildlife Act, and accordingly he submitted that the special PP wildlife is to be informed. Okay, how would do that order? Yate number 20, your good name?
SKSN Mohammed.
Number 22, as I heard Mr. SK SN Mohammed. Huh? Number 22. 2 Mr. Mukhtar is there. And however, CD already received written tickets till linked to listing. The registry is accordingly directed to reflect the name of Mr. B. Sharma, the learned special PP wildlife on the next date of listing. List accordingly on, we are listing on 7th. 7. Somehow we are listing on 7. I don't know how it will be reached or not again.
21.
Lord,
20
you
or
kindly pass over the
2
matter.
or 20. 2 or 20.
Lordship, kindly pass over the matter at 2 p.m. My senior is busy on another call.
Fix it at 2.
At 2 p.m.
22.
22 affidavit or কথা কৈছিল আহিছে
Well, only thing, my lord, definitely on marriage, my lord. One man is, of course, he may have been used, my lord, criminality is there. Totally 100% right. Wife has expired during COVID. 2 children, my lord, he is to look after any convenient date, my lord.
Thursday. Thursday.
First.
On Thursday, next Thursday, on 3rd.
It possible, my lord. Only because the thing, my lord, blind in both eyes, my lord, 1. And the wife has expired during COVID. 2 minor children, only 1 maid servant is there to look after them.
And criminality may be there, my lord, but may have been done by, anyway, my lord, he will have to face the consequences. My lord.
Thursday, you are saying. Thursday is what day? One for he may not be. First will be problem for you, I think.
Most probably, Lordship, there may be holiday.
Oh, first will be holiday, my lord.
There may be holiday.
একটা এখান থেকে বন্ধ দিব।
We are 31st on. 31st is a holiday.
There is a possibility that one may be.
It will be extended possibility, my lord.
Then we have to do work on 31st.
No, the 31st will be already notified as a.
Already notified holiday.
But now it's not sure that whether it will be
no,
observed
it's
on
not sure.
31st or 1st.
No, I don't know.
But there is a possibility. The Chief Justice are also telling that.
Possibility, maybe.
Because here, Lordship, involvement, the allegation against the petitioner is that he evaded the tax amounting to rupees more than 14 crores.
60-day period of.
More than
14 crores.
Yes.
40. Thursday video about it. I do. Okay, that's that.
Both 25, item 23rd also.
Oh, in item 23rd also you are appearing?
My lord.
Both the matters, no?
Both the matters. Diary and report. For records, my lord.
Yes.
We produce all the records along with our.
Along with your objection.
Yes, but that may be recorded.
Record and objection. Record and for filing of objection by the GST, if anybody go to it. Okay, we are proceeding.
Well, can a line, Dada, I think I'm sorry. So Dada, like, can a line be added, my lord, if it doesn't come blind, my lord? There is a prayer for interim. I have not prayed today, my lord. That will be considered on that day, my lord.
How can
No, my lord. There is a prayer for interim bill. We have filed it, my lord. Praying it today. I have not.
Through affidavit?
Yes. We have not.
You have filed the affidavit to that regard only?
No, my lord. Regarding death of wife, and my lord, that 2 children are minor, my lord. Additional affidavit.
Additional affidavit you have filed?
And that is why we have.
No, I thought that in the file the additional affidavit you have made a prayer for interim.
Interim is there in the first application.
First application.
Much of.
All right.
24.
আপনার এই আমার রেজিস্ট্রি সেকশন 4 নয় লাইক না হলে রেজিস্ট্রি লিখতে পারবো সবচেয়ে উপায় নাই বহুত কেস ফাইল করেছে কিন্তু বহুত কেস ফাইলে হয়েছে উপায় নাই এটা কথা কালি ড্রপ রেসপন্স বেরিমিটার থাকিব তো থাকিব নালাগে আসলে বেয়া লাগে নিজৰ we walked till I left yesterday at 8:10 and they left most probably around 9 na around 9 ইয়াতকে বেশি আর কি কাম করে also have this কি item number
24.
oh it's a 24 okay.
Yes, my lord, basically the petitioner, my lord, before lordship, is a victim of an alleged child marriage matter. If your lordship will kindly see the FIR at page number 12. I would like to inform you that Kulsum Bibi, that is the present petitioner, was forcefully married off as a child bride to Abdul Ali, a son of Sonwar Hussain, and consequently subject to regular sexual assault. So that is the FIR, my lord. Thereafter, my lord, police completed investigation, also submitted charge sheet under section 6 of the POCSO Act against Abdul Ali Sonwar Hussain, that is the son and the father. Now, my lord, will kindly come to page number 27. Charges were framed and evidence of the informant was recorded. That is of one Mehboob Ali. He said that, my lord, I am the informant of this case. I don't know the accused persons. So he totally disowned from whatever he had stated in the FIR.
He is the informant.
Informant. Now, after that, my lord, the statement of this victim, and this victim was also recorded by the court. That is in page number 28. 28. Next page. May I read?
No, we don't have 27 PW1.
Yes.
And 20.
They are ordered.
Oh, order you're saying.
Yes,
Acha, acha, okay.
Because though it was stated that it was recorded, but my lord, the form was not there in the record. So a victim is present and examined. While adducing evidence, the victim has stated that though she has delivered the baby, she does not know who is the father of her child. She specifically denied that the accused can be the father of her child and also said that she does not know who the father of the child is. As such, this court is of the opinion that a DNA profiling of the victim, the accused, and the victim child will facilitate the trial of this case. Specifically, my lord, this is our grievance, my lord. The court, my lord, without, my lord, I am the, my lord, an alleged, my lord, victim of a rape, my lord. Now the court, my lord, directed the OC of the concerned police station to do DNA profiling without even recording my consent, where, my lord, there was no such prayer from the prosecution, from the informant, or from the victim side. Directly, my lord, court at the stage of evidence, my lord, straight away directed the DNA test be done, my lord, where I have strong objection and I also do not have consent, my lord. Now the police is pressurizing me to, my lord, give the specimen and also visiting my house. My lord, that is the main contention, my lord, because 184 of the BNSS, my lord, and even in CRPC, my lord, it was specifically mentioned that in case of a victim of a rape, my lord, when it's a woman, then her consent is must, and if it is a minor child, my lord, anybody who can give consent on her behalf, that consent is required. Here, my lord, without even recording consent, my lord, court straight away, my lord, directed the OC to collect DNA sample, my lord. That is my grievance, my lord. We do not have consent, and at least the court ought to have taken some precaution for recording the consent of the petitioner or her child.
So Kulsum, she herself is the petitioner. here.
Yes. And the respondents are the accused persons as well as the informant. All of them have been made part. Thank you.
But you admit the marriage with
No,
the
I
accused.
have my cases of denial, madam.
No, 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 no. As per FIR, you got married with that
Yes,
two,
yes, yes.
one accused
Yes,
person. That is admitted by you.
No,
No, marriage with that accused?
no.
Then you are not the wife of so and so.
Yes, yes, yes. That is why, my lord. In my evidence, my lord, that though a court has said that it was recorded, but that form, my lord, was not in the record. So we could not collect the deposition form. But from the order, it appears, my lord, the victim stated that though she has delivered the baby, she does not know who the father is. So question is not only about the child, but also with regard to the marriage with the accused person.
Yes, that's.
Firstly, this is a question of law, Lordship, but that consent is required. It is true. Consent is required. Moreover, Lordship, here, if this she is not married, then why the charge sheet has been submitted, Lordship?
I don't know.
Then I don't understand that, Lordship.
Well, whatever the
If
police has
nothing
done
is
in
there,
during
so
investigation, my lord,
answer may be confirmed.
culminated
this
into the
stage.
charge sheet. Now we are in the trial stage, my lord. Prosecution will have to establish the case with the evidence. These are the evidences, my lord. These are the evidence of the witness whom the prosecution relied. And these are the witnesses, my lord, who have disowned the case of the prosecution. My lord. Now, what much left to be done in this case, my lord?
Answer may be called for, Lordship.
Okay, we stay in that order.
Yes.
Okay, simply heard Mr. Estes, the learned counsel for the petitioner. Also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent. This is an application on section so and so, so and so. Next paragraph. Here, these are the informant. How many informants are here now?
Informant
Sorry, these are respondents.
Mehboob Ali, he is the informant. And
Mehboob Ali is the informant.
and 2 and 3 are the accused persons.
No, sorry, state of state is 1. Mehboob, you have made Mehboob as 4.
4.
And 2 and 3 are the?
Accused persons. Yes.
Mehboob is the informant.
Informant.
Issue notice to the respondents to register AD and as usual process. No formal notice is required to be served on so and so. Next para, considering the submission made by learned counsel for the petitioner, the order dated 6/1/2025 passed in suppose so and so case number by learned special judge Bilasipara is state. It may be state till disposal, I think, because it's not the issue. I think we have to peruse till disposal for you. Till disposal of the present criminal petition. Also call for the scanned copy of the LCR. But half done is also not there, no? I mean, half of the statement of.
No. We applied for the
Actually,
certified-
while they're supposed to record this, and most probably there was some preliminary, I don't know, preliminary
Probably.
questions probably.
Probably.
On the basis of which it has come out that
Yes,
if she refuses
yes,
to, so
yes.
then. Okay, then it's a question of. We are staying the record
Mine.
and which will be listed after 3 weeks.
Mine.
Sorry, 4 weeks after.
Highly honest.
Yes.
Production list, item 1.
Pune Marks office in late. Need to type 2. Instead also you submitted me that one matter has come where the court satisfaction court is different. So now they are saying that it is the special just NI it is there na. Actually it should be special just no not the station just.
Kamrup Metro. Paragraph 4 I have stated, madam.
Paragraph 4 of your petition.
Petition and in the order of your lordship, my lord, at page 8, paragraph 7, third line. Page 8. Lordship.
Session just Kamrup like that much.
And at clause 3 of paragraph 7, that second line, that will be also, my lord, session judge Kamrup Metro. That corrects me.
On one clause 3 and another
At paragraph 7, lordship.
clause 3.
Clause 3 and the top of the paragraph 7, third line. Paragraph 7, third line from top.
Acha, third line from top. Okay.
And clause 3 of paragraph 7, second line from top. Last from the bottom.
Oh. Okay, we'll make correction.
I deeply obliged.
It will be disposed of. Okay.
I deeply obliged.
Twenty-five.
May I please, your lordship.
Yes.
This revision petition lordship is against the order dated 17/2/2025. By which the Zimma of the prayer of Zimma of the petitioner was rejected. Lordship may kindly.
Have we annexed the order?
Yes, lordship. Lordship may kindly come to page number 29.
29.
This is the order dated 38/2023. My lord. Annex 5.
Yes.
Today the date fixed for report of the IO. The IO has submitted a report wherein he stated that a seized truck bearing registration number so and so loaded with seized oil, which is still in the seized truck. It is further stated the IO has already submitted a prayer before the Honorable CJM Nagaon regarding passing the order of Zimma of the seized oil to the chief engineer so and so, which is awaited. The IO has accordingly stated that above mentioned truck is required for investigation. IO submitted report that vehicle was required for investigation. Accordingly, Zimma was rejected. Now, lordship may kindly come to the next page. 30. This is the order, lordship, which I have challenged. Order dated 17/2/2025. Today is fixed for Zimma report. Zimma report as called for height order dated so and so is received from Raha PS. Seen the report in respect of vehicle bearing registration number so and so, wherein it is stated that ownership of the vehicle has been ascertained. Number 2, the seized vehicle is not required for further investigation. IO has submitted an objection regarding the Zimma of the said vehicle on the ground that the vehicle is still loaded with the seized crude oil. A prayer is already submitted before the Honorable DC Nagaon for passing order for handing over the seized crude oil by so and so to the chief engineer so and so. peruse the Zimma petition, so and so, heard both sides in view of the report submitted by the IO, considering that the seized vehicle is still loaded with the crude oil and pending handover to so and so. Accordingly, Zimma petition is rejected. My lord, Zimma, prayer of Zimma of the petitioner was rejected, Lordship, as because the crude oil, Lordship, which were seized in connection with this PS case, still they are in the trial. And
Well,
Lordship,
I mean, this crude oil had to be unloaded, and if you have crude oil, you cannot go in the road, and
yes.
also it has to be handed over
yes, Lordship,
to the
that is true, Lordship.
company and all.
Yes, Lordship.
So that these formalities are, I don't know whether what is the stage of those things, because there are some formalities through DC. It has to be communicated with so and so for the unloading of this crude oil.
Yes, Lordship.
It's very dangerous also. So
Yes, Lordship. It was started, Lordship, in the year 2023. In the first order, Lordship, the IO has submitted report saying that, Lordship, he has submitted a petition. And Lordship, it is now, Lordship, we are in 2025, Lordship.
obviously. But in 2020, but the order, this present order is of 2025. That is
25.
70
In the
to
earlier
25.
order also, Lordship, 2023, just now, Lordship, which I have referred to, page number 29. Then there also, Lordship, I have submitted that, Lordship, he has taken a step to hand over the crude oil, Lordship.
Steps have already been taken.
In that order also, Lordship, 2023, Lordship. Lordship, may kindly peruse once again page number 29. Page number 29. IO has already submitted a prayer
Seized oil
before
to chief
Yes,
engineer.
Lordship.
Acha.
My humble submission is that, Lordship, let the crude oil be handed over, Lordship. In the process, Lordship, I am supporting, I being the owner of the vehicle, Lordship, and Lordship, if Lordship kindly come to page number 32, Lordship, the registration certificate. This is, Lordship, I have purchased this vehicle, Lordship, by taking financial help, Lordship, from Tata Motors Financial Limited, Lordship. Let the crude oil be handed over, Lordship. I'm not saying that, Lordship.
Okay,
the crude
Mr.
oil,
Das,
Lordship.
you call for a detailed report, in fact.
Yes, Lordship.
Whether that has been already handed over, because there are some formalities has to be, but
Yes.
as he has submitted that the truck is in custody of police since 2023.
2023.
So already almost 2 years gone. So
Express detail order needs to be there.
detailed report.
Yes, sir.
What is the stage, what is going on, whether there any steps has been taken. Because simply saying that the this truck is loaded with crude oil will not suffice now.
Yes, sir.
Yeah, I only wanted to state a logic on 38/2023, the prayer was made before seizure. It is only in 17 to 2025. It is stated that the prayer is made before DC Nogao.
Whatever it may be.
Not on that occasion, Lordship, on 2023, not to.
No, but in 2023 itself, if you go by the order, it is further stated that IO has already submitted a prayer before the Honorable CGM Nogao, passing order of Jimma
Lordship.
of the seized oil to the Chief Engineer so and so limited.
Lordship.
So that was already,
That is also there.
that was
Lordship.
there.
So, Lordship, may one copy may be furnished to me so that I can
Yes,
forward it to the IO, Lordship.
Yes, sir. I will furnish extra copy. Then. Sure.
Order copy of this court, Lordship, honorable court.
Heard Mr. M. Ahmed, the learned counsel for the petitioner, and also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent. And this is an application for Jimma sought for law. It is submitted by Mr. Ahmed that the truck is in custody of police since 2023, and on 38 2023, 30/08 2023, an order was passed rejecting the prayer for Jimma with a consideration that the truck will be required for further investigation, and one observation was also made that the IO has made a prayer before CGM Nogao regarding passing of order of Jimma of the seized oil to Chief Engineer (OPS) Oil India Limited, which is awaited. But subsequently, on another Jimma petition was filed for the seized truck, and by the order dated 17/2/2025, The prayer for Juma was again rejected with an observation that the vehicle is still loaded with seized crude oil, though the prayer has already been submitted before the DC Nagaon for passing order for handing over the seized crude oil to the Chief Engineer bracket or OPS Pump Station 4, Sekoni, Jokhalabandha, Assam, which is under process. He further, Mr. Ahmed further submitted that the present petitioner is facing very much financial trouble as the truck is in custody of police since more than 2 years, which was purchased by him through hire purchase. In view of this, later detailed report be called for from the concerned IO as to the status of the crude oil which was seized in connection with this case, and to report as to whether the or all other formalities has already observed for handing over the crude oil to Chief Engineer OPS so and so on or before the next date of listing. The additional PP will also personally communicate with the concerned IO in that regard. Copy of order be furnished to the additional PP to do the needful. List accordingly after Bihu it will be listed immediately after Bihu.
22nd?
No, day 20 weeks. Immediately after Bihu.
Highly applies.
26.
Yes. That's it. This revision petitions against the order dated 11/25, page number 89. In this case, the procedural case record, it shows that a copy of the impugned final order dated 33/24 along with a copy of judgment dated 21 sent to the concerned OC for information and necessary actions. In view of the above, the concerned OC is directed to comply with the final order dated 13/3/2024 and judgment dated 21 to ensure that the respondent restrain the themselves from disposing the aggrieved person and her child from her matrimonial house. Kindly my lord, go to page number 67. Which was 33 order was started from page number 60. If we go to the page number 67, this order was passed by the judicial magistrate that the respondents are directed to restrain themselves from dispossessing the aggrieved person and her child from her matrimonial house. In 13.3, page number 67, in order 13.3. Which was modified by the criminal appeal number
what 13.3?
Page number 67.
This is the order of 13.3.
3.
13.3 order.
No, page number 67.
Yeah.
Para number 13 and subsection subpara 13.3. The respondents are directed to restrain themselves from dispossessing the aggrieved person and child from her matrimonial house. This order was modified by the Honorable District and Session Judge, number 2, Nagaon, which is page number 77. This 13.3, the order dated 13.3 was modified by the Honorable District and Session Judge on 22/1/2025, which page number 77. This one, order person paragraph 13.3, chapter 3 of the impugned final order is modified, and its place is directed the respondent number 1, the husband of the aggrieved shall pay her amount of rupees 1,500 per month as rental amount with effect from the date of filing of the petition from 22 month, and area rental amount shall be clarified him within the period of 6 months from the date of this judgment, and failing which the same shall be recovered accordance with the law. And in number 2, the copy of impugned final order 13.3 along with a copy of this judgment shall be sent to the OC concerned by learned magistrate for information and necessary action in view of the section 24 of the Act, which was morely clarified in page number 84. This in discussion. My lordship.
Paragraph,
Uh,
please.
Page 84. Morely described and beautifully described by the Honorable District and Session Judge. That's paragraph number 10. So far as the direction to the respondent to restrain themselves from the disposal of the aggrieved person and her child from her matrimonial house is concerned, perusal of the petition of the aggrieved reveals that at the time of filing case, she was residing in her parental house. The aggrieved and her husband were mostly residing in a rented house during their conjugal life. They did not reside in his parental house for a considerable time. At the time of the aforesaid direction was passed by the learned magistrate, the aggrieved was already residing in her parental house. Vide a petition number 136/24 dated 9/2/24. C, however, prayed for a residence order and protection order as she desired to go back to the matrimonial house, that is parental house of her husband. Against the said prayer, however, she indicated the prayer portion of her main petition that she fears for her life as well as the life of her daughter, for which she did not pray for any residence order in her main petition. This fear was repeated in her evidence on affidavit as PW1 at paragraph number 35 to K by stating that there is no option to staying in his house in the house of the respondents. Against this express fear to reside with the respondents in their house, she filed the aforesaid petition number 136/24 dated 9/2/24, wherein she expressed her desire to reside in her house, the respondents with the help of the protection order. She stated in her said petition in paragraph 3, amongst others, that she tried to go to the matrimonial house, but the respondent insisted her not to enter in matrimonial house and also gave threatening that if she enters the matrimonial house, in consequence, it will be very bad. In paragraph 11, she further expressed her desire in her main petition as well as her evidence on affidavit. She resided to rented house at sought for rupees 5,000 as rent for the same. In the light of this material, the aforesaid direction could and should not have been given, as the same appears to have been passed on the assumptions that the aggrieved was already residing in his shares household, whereas she was in fact residing in her parental house. In view of the clear perceptions of the threat of her life and the life of her daughter, this court is also to view that it would not be safe for her and her daughter to reside with the respondents in the same shared household. A separate amount for rent would have been more appropriate under the circumstances. Therefore, the state direction needs interference from this court. And in page number 87, this order was in view of the foregoing in paper number 16. In view of the foregoing discussion, the reason is appeal in partly allowed on contest. The aforementioned impugned final order dated 13/3/24 is modified to the extent indicated below. Order passed in paragraph 13.3, which was in main order dated 13/3/13 subsection 3 of the impugned on final is modified, and its place it is directed that the respondent number 1 to husband of the aggrieved shall pay her an amount of rupees 1,500 per month as rental amount with effect from the date of filing of the petition 21/2022. The area rental amount shall be cleared by him within a period of 6 months from the date of this judgment, failing which the same shall be recovered in accordance with law. And second, the copy of impugned final order 13.3 along with a copy of this judgment shall to the OC concerned by learned magistrate for non-remission and necessary action. But the learned lower court misinterpreted this order and filed an order then order dated 11/3/25 and ordered in view of the above, the concerned OC directed to comply with the final order dated 13.3 and judgment dated demand to ensure that the respondent restrain themselves from the disposing of the aggrieved person and her child from the matrimonial house.
Which order?
Page number 89.
Oh, last order.
Last order. Which was already modified by the 13th order, also modified by the criminal appeal, but Manalarid lower court misinterpret this order. So it is necessary to stay the proceedings of the entering the aggrieved to entering in my matrimonial house.
So what you need now?
Already I paid the rented amount in my court. This court is necessary to stay the proceedings of this
Rental you are paying now?
already, yes. She clearly stated her petition.
So why this order is silent about the revisional court, order of the revisional court? Order of the session judge is not mentioned here.
And there is this, in view of the concerned OC direct to comply with the final order dated 13-3 and judgment dated 23 ensured that this was misinterpreted by the learned lower court that
Your
13-3
this
order was already
appellate
modified.
court order is on 22-1.
22-1.
Your MS Medhi or Kalita?
MS Medhi.
Medhi. Heard MS MD Medhi, the learned counsel for the petitioner. I also heard Mr. KK Bush, KK Raj, the learned edition PP, appearing on behalf of state respondent number 1.
Respond number 2, Lordship.
You are respondent number 2. State is respondent number 2. No formal notice done again. Issue number like 144. For the scan copy of the LCR. Further, considering this submission made by learned counsel for the petitioner, it is seen that it seems that there is some misinterpretation of the order passed by the learned additional session judge. Additional session judge in case number. Additional session judge number 2 in appeal number.
Criminal appeal number 20.
Criminal appeal number 20 of 2024.
24. 33 of
2000 sorry, 37. Dated 22/1/2025. In view of this, the order of dated 11/3/2025 passed by the Court of Learned GMFC Nagaon in DV case number 23 of 2022 is hereby stayed till next date of listing. However, the petitioner is hereby directed to pay the monthly rental as directed by the appellate authority, appellate court. List accordingly after 4 weeks.
High level listeners.
Submission Mr. Bhuya, your case is at
29. All right, I'll come
after a break.
after at 2.
There was some correction and all, whatever. That day you have already made some. Okay.
Lordship.
Your petitioner is in custody.
Yes, Lordship.
So do you have any instructions?
Yes, Lordship.
You are MS?
Ego go, Lordship.
As per instructions, so and so corridor matter is disposed of on withdrawal. Okay, it will be disposed of on withdrawal.
Production list item 3.
This letter has been submitted, therefore I may pay for withdrawal of the petition.
What has been submitted?
Charge sheet has been submitted, my lord. Charge sheet number 29 of the 2025. It was submitted on 23/3, my lord.
29 of
2025.
Is submitted on 23/3/2025.
23/3/25.
The liberty to file a petition for the trial court below, my lord.
Yes, that liberty will be given. Liberty in a sense, you are at liberty to file a fresh application. Okay. Search number to Lucy. Okay, it will be disposed.
Hello.
Picture 2, item 5.
Yes.
The petitioner is under subsidy since 16/11/2023 lordship, under section 21C and 29 of NDPS lordship.
Since when?
16/11/2023. Search sheet was submitted on 16th of February 2024 lordship.
16?
February 2024.
Yes.
Till date lordship, no witnesses has been.
Charge is also from or charge
From
frame?
lordship.
Charge frame when?
So
Okay, now as per your information,
I have annexed all the lordship
orders.
orders till 3/3/2025 lordship.
It is a fixed evidence. How many witnesses? Do you have any idea?
Till that, no witnesses has been examined lordship.
Yes, Borwa.
Certificate case, my lord. May I pray to call for extension of the record?
So you have annexed the order sheets, but
Lordship.
it's not here as to if any evidence has been recorded. Suppose if evidence is recorded against you, if there is no material at all. So that may be a case, but we don't have anything now in our presence. So we are calling for the scan copy of the case record. Scan copy of the case record along with the case diary we call for. When it can be fixed, Purva?
After vacation.
After vacation. Do you want any fixed date here?
That may be fixed lordship.
Second of 8, 5.
Second of May.
Present status report also will call for.
Obliged.
And if you have any instructions regarding the recording of evidence, etc., you can submit through an additional evidence.
Obliged.
21.
Yes, 21.
Yes, may I please your lordship, 483 petition, my lord. In this case, my lord, the petitioner was arrested in connection with, my lord, intermediate quantity, my lord, 21B stroke 29 of NDPS, my lord. My lord, petitioner was arrested on, my lord, 2/3/25, my lord. And my lord, kindly have a look at, yes, my lord, annexer 3, my lord. Annexer 3. At first, my lord, I would not like to go at first FIR, my lord, because, my lord, in Annexer 3, kindly. Paging, my lord, I have some confusion here, my lord.
No, page, which page?
But my lord, on my last page, my lord. Annexer 3, my lord. Some irregularity is in my office copy, my lord. That's why I'm. Annexer 3, my lord, seizure list. That is seizure list, my lord.
Seizure list.
Seizure list, my lord. In seizure list, my lord, the alleged articles were, my lord, were seized on 1/3/2025 at around, my lord, 8:20 p.m., my lord. 8:20 p.m., my lord. Now, my lord, you lordships kindly come to page, my lord, page 11 of FIR, my lord. FIR. Apparently, actually, there is no case, my lord. As because from the contents of the FIR itself, my lord, it shows that, my lord, that there is no case. As because
FIR is at page?
FIR at page, my lord, 11, man. Page 11. Yes, sir. Yes, sir. This is to inform you that a reliable information was received from a secret source today, that is on 1st March 2025 at about 8:24 p.m. my lord. It is very much specifically stated in the affair that they got information at around 8:24 p.m. my lord. And thereafter, my lord, accordingly, PM, that some drug peddler are coming to sell huge quantity of NDPS substance at Gorsuk PS area. Accordingly, thereafter, my lord, general diary entry was made by the officer in charge. It took some time, my lord, of by Gorsuk PS GDNT number 32 dated 1/3/25 and directed me along with available on duty staff for doing lawful action. Thereafter, my lord, the information received suggested likely to operation of entry, search, seizure, arrest, etc. may continue even after sunset. Accordingly, OC Gorsuk PS issued me a written authorization as per section 41 within bracket 2 of NDPS Act. I have collected NDPS kits which is available at PS from Sirestadar. I along with available PS staff proceeded to the PO for initiating necessary action. My lord, it took much more time, my lord, as because inside the police station to preparation to proceed the place of occurrence, my lord. But whereas, my lord, they got information, my lord, at around, my lord, at 24 p.m., my lord. But unfortunately, they went to the place of occurrence and thereafter, my lord, arrested the accused person, my lord. And thereafter, they seized the LS articles, my lord, LS materials. Because much more earlier, my lord, they prepared earlier before lodging the affair, my lord. Before receiving the information, my lord, they prepared the seizure list earlier. And my lord, in this context, I have stated the details in, my lord, in para 7 of my petition, my lord. Para 7. Kindly have a look, my lord, at para 7, my lord. Then matter will be clear, my lord. Case is manufactured one, my lord. Entire allegation, my lord. Kindly have a look, my lord.
Yes, I have seen. Yes, board.
Question is that, my lord, the containment recover from their position, my lord. And whatever the discrepancies, my lord, that will be the matter of trial, my lord. So when the, my lord, I will be interrogated, my lord, you will explain all these questions, my lord. Now, my lord, Prama said there, my lord, there is material because, my lord, this containment was recovered from 2 persons, my lord, including the present petitioner, my lord. So may I pay to, my lord, call for a case diary, my lord?
Yes, obviously we need the case diary because the entry in the case diary is also a very material. When the GD entry was recovered, where there may be some slight discrepancies regarding the
That
timing.
maybe happen.
But the question is that on 1/3/2025 itself, the information was received, and on that the work of search or seizure operation was conducted, and they were there. There may be, yes, he has rightly submitted that.
Yes.
The timing, there's a difference in timing,
Yes, so
but we have to see the case
And
diary.
what happened on that day, my lord? The petitioner, my lord, he is a small lord, the small shopkeeper, my lord, and doing his shop at roadside, my lord, street shopkeeper, my lord. And he was opened his shopkeeper, and at the time of, my lord, closing his shop, my lord, there are some persons, my lord, they're gathering nearby his shop, open shop, that is, my lord, street shop, my lord. There, at the time of closing his shop, my lord, there are some gathering, some persons were, my lord, gathering nearby his shop, and then the police came, my lord. Then the police came, and all the persons, my lord, fled away. But thereafter, my lord, these innocent persons were picked up to interrogate him, my lord, at police station. He knows nothing, my lord, and thereafter, on interrogation, he came to know that a case has been registered and booked him in the case, my lord. Yes, sir.
Unfortunately.
The actual culprits, they have
Fled away.
most probably, my lord, they have fled away. And on the plea of, my lord, interrogation, he picked up to the police station and thereafter interrogated. And on next day, my lord, he came to know that he was booked in this case, my lord. Along with his minor son, my lord, 15 years.
He's already been declared as my lord, juvenile my lord, and he's my lord now exiled home. Bamunigaon my lord.
We have to call for the case date.
Yes, my lord, very short date, my lord. That's why.
We
my
don't
lord,
have any short
already-
date. How can we calculate?
If possible, my lord.
It's not possible.
25 for my lord. Today is my intermediate quantity, my lord. That's why I am paying, my lord.
No, what to do?
Only
We
my
don't have any date. Huh? Yes.
Yeah, only my lord, this quantity
Only
is
maybe, quantity maybe, we don't have any date.
only 52.67 grams, my lord.
To do what to do? We don't have any alternative. No?
There's already, my lord, 2, 3, my lord, 27 days already in jail, my lord. He's the only.
Still we have 33 days. Okay, we are listing it on 21, 22, 41, 81. This 23.
21.
20,
Just,
okay, then 21.
just after opening the, my lord.
Is 21 is the opening day. 21 is the open. City call query 21.
Obliged, my lord.
27.
May I please lordship, my lord, is petition for quashing of the criminal proceeding pending against me, my lord. And my lord, matter has been suscited, my lord, and my niece, my lord, lost an affair, my lord, against me, my lord. Kindly turn to page 16, my lord. Annexure 2, my lord. Affair, my lord. May I read, my lord? With due respect, I would like to state that I am the legal heir of Miss Binapani Bora, who expired on the 23rd June 2021 at the Apollo Hospital, Guwahati, due to post-COVID complications. Thereafter, a relative, namely Mr. Umit Kumar Bora, myself, my lord, the petitioner, my lord, Umit Kumar Bora, had taken the responsibility to apply for the death certificate at the office of the Deputy Director of Health Services at Kharguli, with an understanding that the same will be handed over to me in original on receipt from the authorities. I have been calling Mr. Bora to inquire regarding the death certificate, but he has not received my calls. Yesterday, my cousin had called him in the same connection, which he duly accepted the call and denied having taken the death certificate from the authorities, saying that he has applied for the death certificate only a few days back. However, I have now come to know that the same has been duly collected but has not been handed over to me as yet. Besides, the above, my legal guardian owned one private car bearing registration number so-and-so, which was parked at Upada apartment, Rajat Kamal Pod, Guwahati 24, where she resides. The said car has been removed by Mr. Bora on the 8th of July under the pretext of having it repaired. However, I have been informed that he is looking for a customer to sell the same. I would request you to kindly inquire and restore the said car to me at the earliest. So, my lord, two allegations, my lord, that my lord, original birth certificate, death certificate, I has not been, I has not, my lord, provided to her, my lord, and car was taken by me, my lord. Now, my lord, kindly turn to page, my lord, 31, my lord, page 31. My lord, this is Binapani Bora. She is my lord, sister, my lord. I am the legal heir, my lord. Kindly turn to page 31. I am the second class, my lord, legal heir, my lord, page 31. My lord, this is my lord, next of kin certificate issued by the Kamrup Metropolitan District, my lord, and relevant portion, page 32, my lord. My name appears, my lord, Umit Kumar Bora, my lord. Name of kins, Umit Kumar Bora, relationship brother, my lord. After issuing this certificate, my lord, they, my lord, filed an objection petition for cancellation of this one, my lord. Kindly turn to page 33, my lord. Page 33, my lord. My lord, they filed this, my lord, complaint, my lord, for cancellation of this, my lord, next of kin. My lord, after hearing both the parties, their petition was dismissed, my lord. And
their petition.
Yes, my lord, because I am the, my lord, only legal heir, my lord. That is why, my lord. So family dispute, my lord, and prima facie, my lord, as per the affair, my lord, no, my lord, criminal offense has been made out, my lord. But charge sheet has been submitted. I have been summoned, my lord. And subsequently, my lord, warrant also has been issued, my lord. I am a government service. I am, my lord, central government service holder, my lord, working in, my lord, Negrims, Shillong, my lord. Today is my date of retirement, my lord. So, my lord, unnecessarily went for harassment, my lord. Prima facie, my lord, as per FIR, no offense is made out, my lord. I am the only legal heir, my lord, that, my lord, as per the order date, my lord, of the deputy commissioner, and also, my lord, next of kin certificate is also here, my lord. So, notice may go, in the meantime, my lord, proceeding may state, my lord.
Such is that case, my lord,
Yes,
so
my
notice may be issued, my lord. And notice
Yes.
may call for them under LCR, my lord.
Yes, LCR may be also in, call for in the
No,
meantime.
let the opposite party appear, my lord, after that, my lord.
My lord,
His prayer for stay may be
my
considered.
lord, prima facie case is there, my lord, because, my lord, I am the legal heir.
So it
my
is
lord.
a such that case, my lord.
That
My humble submission.
maybe, my lord, proceeding may be state, my lord. And 406 and 420, how can, my lord, as per the FIR, my lord, how can I attack, my lord?
And Mr. S. Sikdar, the counsel for the petitioner. And also heard Mr. R.J. Boro, the learned additional people bring on behalf of state respondent. This is an application on section so and so in connection with so and so. Issue notice to the respondent number 2 to reinstate AD and usual process. Also call for the scanned copy of the LCR along with the case diary. Next product, considering the submission made by learned counsel for both sides and the privacy materials available in the case record, I find it justified to stay the further proceeding in case not relation to connection. How many accused? You're just only accused?
Only, my lord.
Is it, we state till next date of listing, list accordingly after 4 weeks. You take steps.
My lord. Highly obliged, my lord.
Twenty-eight.
Yeah,
Yes,
please.
28.
This is a criminal petition, your lord. This is for the quashing of the affairs, charge and the entire proceedings of the petitioners. And the petitioners herein is a mother, daughter, and a son. And they were falsely alleged in a case under section 294, 352, and 34. This is a matter when the completion, after completion of the evidence of the prosecution, 4 number of prosecution witnesses have deposed. And 2 defense.
294 is not compoundable. No? But oh, you have are you coming for you have filed this one for washing?
Yes.
Achha.
Now, in this case, 4 number of prosecution witnesses already deposed. And again, 2 BWs were also reduced the evidence. 313 statement was also made. Thereafter, it was fixed for judgment on 21/3/24. It is on page 35, your lordship. Wherein, on that date, your lordship, may I read it? Today is fixed for judgment. All the accused persons are present. However, while preparing the judgment of the instant case, it came to the notice of the court that the FIR, the informant Lavanya Das, has stated that the accused person had verbally abused her daughter's victim, namely Moromi Das, and also pulled her daughter's hair and dragged her in the floor and slapped, kicked, and also pulled the victim. On the perusal of the evidence recorded before the court of PWs, namely PW 1 and 2, it is seen that both the PWs have stated that the accused person called Moromi Das and then the accused person assaulted her. However, the said victim, Moromi Das, has not been examined by the prosecution side and the name of the said victim is not been listed in the witness column of the charge sheet. In the view of the above, the court deems it fit to issue summon to Ms. Moromi, resident of this, under the provisions of section 311 of CRPC to arrive into a just decision of the case. Accordingly, we have not opposed to the CW was called. She was also cross-examined. Then lordship again, the matter was again fixed for judgment after hearing both the sides. Argument was made, and lordship may turn to page 36, where judgment, it was fixed for judgment on 2 dates. The judgment was not being passed, and again lordship thereafter on at page 40, your lordship, at 30/08/24, at page 40. Again, the judgment was not being passed, and the order was so made that today is fixed for judgment. All the accused persons are present. While going through the case record for preparing the judgment, it is seen that there are materials available against the accused person under section 323 IPC in addition to 294 352 and 34 of IPC. Peruse section 222 of CRPC, according to the CRPC, the 222 subsection 4, 323 IPC is a higher offense as compared to section 352 IPC, hence judgment is not pronounced today. And accordingly, the court deems it fit for giving an opportunity to 217 CRPC to the defense side for recalling the witnesses as the charge has been altered and added. Now, your lordship, while passing this order, your lordship, the very line that is made in this order, that while going through the case record for preparing the judgment, it is seen that there are materials available against the accused person under section 323 IPC. In addition to the same, it is very well understood that the learned court has made up its mind to convict the accused person by the alteration of these charges of the though the petitioner are completely innocent in this case. Now, lordship, while passing this order also, lordship, may kindly note that no reasons has been mentioned in this order that why the charges has been altered. Why, under what circumstances, under what evidences the charges has been altered by the court for in this case from the record. Nothing has been mentioned by the victim that she has been injured. She has been assaulted. Even for the sake of argument, if we say also assaulted 352 was there. But 323, in order to attract the section 323, there was not a single witness who have mentioned about the injury. Moreover, she was medically examined, nor she was no medical certificate is there in the record. Even then, 323 has been brought into it by ordering the charges. Now, a humble submission before the court, your lordship, is that in order to this is a case fixed on 1/4/2025 for re-examining the witnesses. Now, if the lordship is not pleased to suspend the proceeding in this case, then the same we have to take the evidences and again go for judgment, and there will be very chances of convicting the accused person, your lordship. So, my humble prayer to stay the proceedings for until further orders in this case, because this matter is fixed on 1/4, your lord, and is fixed for the re-examination of the witnesses again. So otherwise, this petition will be infructuous.
My lord, the order impugning this petition, my lord, that has been passed, my lord, after the recording of evidence of the CW, that is the victim of the incident, my lord. Now, lordship may kindly see, my lord, come to my lord, page number 36, my lord. Why the trial court has, my lord, passed this order to alter the charge, my lord. Page number 36.
Yes.
Lordship may kind of down below, my lord. 4-5 line from below, my lord. One Kamini Chaudhary who was present in the picture gave me blows with her hair. Thereafter, the other accused persons, namely Tapun Chaudhary, Sumi Chaudhary, Pradeep Chaudhary, also assaulted me with their hands. Sumi Chaudhary tore my hair and I was fell on the ground. My mother, Lavanya Das, came and rescued me. Me and my mother went to PS and lost this case. Police took me to Panpuzar Medical for my medical examination.
But lordship, just a single medical paper is there in the record, nor she has been examined. She has never stated that she has stated in the cross examination, lordship will find that there is nothing in the record in regards to the in regards to the medical examination. And the Pradeep Chaudhary, if I get into the case inside of the case, the Pradeep Chaudhary, he is in the FIR, but he has not been searched. He had a broken hand in that period of time. And he has been wrongly engaged in this case. He is the husband of the Kamini Chaudhary. And the entire family has been engaged in this case because the son of the informant was caught by the police for taking ganjas and all in the house of the one small child. So the entire village people came there, and the Lavanya Das son was taken.
So you come before this court only for the observation made by the learned trial court below, wherein it is clearly stated that there are the CW, victim is required to be examined. After examination of the victim, it has definitely come before the court that there are materials. There are materials for 323.
Yes.
That's why the charge is altered.
But lordship,
so now how can you express? It's not a case of.
This order was passed on 3/8/2024.
Yes.
Now
so
they come
waited,
after 9 months.
Now we have
why you waited for 9 months?
No, we have not challenging this order, and we have come for the quashing of the entire proceedings upon the petitioner, because the entire
at this stage of evidence judgment. You have come.
Yes, Lordship, because there is a.
Why at this stage of judgment you have
Because
come?
before judgment.
No, why you waited for since 9 months? The order was passed on 38, 2024 itself. Then why you waited?
There was certain difficulty on the part of the.
No,
petitioner.
whatever,
They
that is your
projected
difficulty.
only the
notice issue, madam, only
Yes,
notice
notice
issue.
issue, notice
Because
issue.
Lordship,
It's not at all a case, not at all a case.
Because in order to order the charges, Lordship, it should have been mentioned about the reason why the charges.
Yes, you see, there are sufficient reasons why it has been altered. Initially, by the time of judgment, this court practices definitely has to be reported, rightly observed that why the victim was not examined when there's a sufficient evidence that victim was assaulted. So that's why court find it necessary, very necessary that the victim should be examined, and accordingly she was examined as a CW1. Sufficient materials are there to, frame charge against 323. That was not so initially, definitely was there.
There was no medical examination.
No, whatever, medical. So
And she has
323, if you feel pain also, then also it is 323. It is not a case that you have to be there, has to be some cut injury, red injury, mark injury, laceration and all this has not to be. It's not the case. If you simply feel pain, if you cause voluntarily, if you cause hurt means hurt is hurt only. If you feel pain also, then it is also hurt.
If your Lordship
Criminal
has-
assault is 352 is quite different. It's not 323.
Clearly,
We are issuing notice on Mr. Hussain. We are unable to, we are not in a position to say anything. A Hussain Corridor, issue notice corridor. Oh, sorry, submit notice issue corridor. We are on 20. Oh, sorry, 28. Yes. Issue simply issue notice corridor or call for a scan copy of the LC. That much only we can do. Outright, it's not a case for quashing, if you see by the record. Anyway, issuing notice after at least after 3 weeks.
Also.
29.
Yes, Mr.
Lordship, this petitioner,
Hmm.
he is the younger brother of the husband of respondent number 1. And
Younger brother.
Younger brother.
Hmm.
Husband of respondent number 1 and father of respondent number 2. So their relation is brother-in-law and uncle. So far the petitioner is concerned. So the husband of the petitioner is, so husband of the respondent number 1 is still alive.
Husband of the
Respondent number 1 and father of respondent number 2.
That is Dhirendra Chandra Das.
Yes. Dhirendra Chandra Das and Moni Das are the brothers. And they have other 2 brothers also. There is a property at Topobari, Guwahati, that is the having G+1 RCC building. It was an ancestral property. So after the death of their predecessor, they started to reside separately. So in the year 2005, there was a suit for partition in respect of the said property amongst the 4 brothers. And it was ultimately partition decree was passed in an appeal. And accordingly, property was partitioned in the year 2010. And before partition also, they are residing separately. And after partition also, they are residing their respective share of property. So ultimately, what happened? In the ground floor, your lordship, the younger brother, younger son of the original owner, he got his share in the ground floor. Dhirendra Chandra Das and Moni Das, they are residing separately in the first floor. And the ground floor, there are 2 parts. In the ground floor, there are 2 parts. In the upper floor, first floor, there are 2 parts. So the younger son, that is Shekhar Das, he got his share in the ground floor. And that in the year 2015, that younger brother, Shekhar Das, agreed to sell that property, his share to Moni Das, that is to the petitioner. So ultimately what happened? He did not sell it out, although he initially agreed to sell, but later he sold it out to the present respondent number 1 and 2, who is the wife and daughter of Dhirendra Chandra Das. So when he has come to know about the sale of the property, this petitioner immediately filed a suit for specific performance of contract as well as for cancellation of the sale. That suit is pending in the Court of Civil Justice Senior Division number 2, Kamrup Metro. Suddenly what happened? Suit is still pending. In the year 2015, in the month of March, in the said suit, they filed a written statement also. They are contesting it. That the respondent number 1 and 2, they are contesting it. They filed a written statement stating that after purchasing that property, it is under the property under their possession, it is lock and key. Because Monidas said in this suit that he is in possession of the property, he kept his belongings in the property. So that is why that the injunction is to be granted. And the injunction matter is not yet granted. And their claim is that no, Monidas is not in possession. We are in possession. After purchasing that property, we are in possession. We are kept in the premises under lock and key. And suddenly in the month of March 2025, first week, when the petitioner Monidas was at Delhi, suddenly this respondent went to the premises because they are residing in the first floor. Monidas is residing on the first floor. Separately, they are residing. They tried to throw the belongings of the Monidas. When they have come to know the wife and sons, they come to know that immediately they obstructed it. They informed the police. When they went to the police station, they informed it that there is a DV proceeding, there is an order of a domestic violation case. At till date, no notice has been served, no information has been given. When we have
No,
come
against whom? Against whom DV proceeding?
DV proceeding against Monidas.
By his wife and son. Wife
No. By
whom?
the wife of his brother, that is wife of Dhiren Das and daughter of Dhiren Das.
Acha, acha.
They are not living jointly, they are living separately. There is no shares household.
So they file a DV proceeding.
They file a DV proceeding alleging, concealing the fact that there is a civil suit is pending. That the proceeding, that the application they have filed at page annexure 4, your lordship, page 54. Lordship. Aggrieved persons, Cephali Das, wife of Dhiren Chandra Das. 2, Tulika Das, daughter of Dhiren Chandra Das. And they are aggrieved persons, and the respondent is Moni Das. This is the present petitioner before your lordship. And this application has been filed under section 12 of the Protection of Women from Domestic Violence Act 2025. Alleging that Monidas harassed them and it is their purchased property and they have not, that the Monidas did not allow them to enjoy it. So that is why this petition has been filed and they have sought a order from the learned trial court under section 19, subsection 1. The protection is required. So accordingly, some of the requirement they have, which is necessary, that was obtained from the protection officer order is there. And I am on that at annexure 5, your lordship, page 78, initial order. 21/11/2024. And by that order, the petition was entertained. DIR report, domestic incident report was called for. Next date has been fixed on 7/2/2025. It page 79, your lordship. That is 7/2/2025. The order has been passed. And Ultimately, the impugn order has been passed at Annexure 6, page 81. Lordship of it. Aggrieved person number 2 is present. Respondent is absent because he was at that time, he was at Delhi. The learned counsel for aggrieved person has submitted the track consignment report of the postal notice issued to the respondent, which reflects that the notice upon the respondent could not be delivered as it was refused. Hence, notice against the respondent is deemed to be served. As the respondent is absent today, this case shall now proceed ex parte. The learned counsel for the aggrieved person has submitted that the present case there is an urgent need of allowing interim relief to them, as the respondent has been causing hindrance in the enjoyment of peaceful possession of their purchased property. It is admitted. Purchased property. This is not a shares household. Purchased property. The learned counsel for the aggrieved persons has submitted that the respondent is the brother-in-law of aggrieved persons number 1. And the aggrieved person number 1, after her marriage, has been residing in her matrimonial house, that is house number 78, Horen Kolita Pot Tokobari, with the respondents and other members of the family, thereby sharing a domestic relationship. Aggrieved person number 2 is the daughter of aggrieved person number 1 and was married to Sharad Datta out of the wedlock. Aggrieved person number 2 and so male child was born, who was at present 4 years old. Later on, Sharad Datta died, and at present, aggrieved person number 2, along with her minor son, has been residing with the aggrieved person number 1 at house number 78. It has been submitted that the aggrieved person purchased the house in the above mentioned building by executing a sale deed, but the respondent, taking advantage of his masculinity, has been interfering and creating hindrance in the peaceful enjoyment of the property of the aggrieved persons. The respondents, by using criminal force, locked the aforesaid house, thereby prohibiting their access. The aggrieved person number 2 is a widow lady and has no source of income of her own. She could have earned something by letting out her property, but the respondent has created hindrance and obstructions and even has been trying to remove them from the their lawful possession by repeatedly threatening them. Hence, the aggrieved person have prayed for an interim protection under. I have heard the learned counsel for the aggrieved person at length. The respondent choose to remain absent by the refusing the summons. At this stage, the prima facie materials available with the records, which includes the sale deed, reflects that the aggrieved persons have lawful right in shared household. How did court come to conclusion? They are living separately. This portion purchased properties belongs to the Shekhar Das in the seat at the ground floor. They purchased it. And Shekhar Das was the owner. They purchased it. Definitely they purchased it. And their sale has been challenged before the land trial court. Now I am coming to the written statement and file item. What
No,
they
it's
have
okay.
said.
I have come to know that
Not-
there is in fact, it's a family oblique this civil dispute is going on.
Yes.
And obviously, is a purchased property in
Right.
fact. So share household, question of share house doesn't arise.
Doesn't
at
arise.
that. Okay, we'll stay. What is
Lordship.
the stage of the case at
Lordship.
present?
Right now, the interim order was passed. Today, date has been fixed. Today, we appeared and filed an application before the learned trial court also. So the proceeding may be stayed in the meeting.
So state is not here, party, na?
No,
You're not.
that is not a part.
Heard Mr.
Private.
R.K. Finalizing, learned counsel for the petition. This is an application under section so and so in connection with so and so. Issue notice to the respondents and also call for the scan copy of DLC. Further, considering this submission made by learned counsel for the petitioner, it reveals that sorry. Further, it is submitted by Mr. Bhuyan that suppressing the pendency of civil suit for the said property. One DV case has been filed by the respondent number 1 and 2 with some false and concocted allegations, and without even verifying the the case as to the due of the finding of the without even verifying the property with no, sorry, without even considering the fact that the property which is alleged to have been wherein the property which was where they claim for their disposition is a purchased property. Accordingly, he submitted that the further proceeding may be stayed till disposal of the so and so. Next, for considering the submission made by Mr. Huya, the counsel for the petitioner, the further proceeding in the case number so and so pending before learned GMFC so and so be stayed till next date of listing, list accordingly after 4 days.
Lordship.
You take steps for the
Lordship.
30.
May I please, your lordship? Okay, this is an anticipatory bail application. My lord, section 4 of POCSO Act is there, my lord. So at this stage, my lord, CD may be called for. And my lord, notice may be issued to the respondent number 2, my lord.
Respondent number 2.
Yes, my lord.
Okay, we are issuing notice. Notice be issued to the respondent number 2 to Judicial Police Station, noted to the Office of the Registry and the Public Prosecutor. Also call for the as CD. You are in custody since when?
No, my lord, this is anticipatory bail application.
Oh, sorry, anticipatory bail. Yes, case diary be called for. Yes, Borwa.
So Mayang, my lord, short date may be built before Bihu, my lord. Any
We don't have any short date.
My lord,
Yes.
10, my lord.
23, my lord.
23. Try to manage somehow. It is anticipatory bail only.
Yes, madam.
23 for take steps for issuing notice.
My lord. I'm online.
31.
Please, your lordship. Lordship, POCSO is there, lordship.
POCSO is here.
For case diary.
Yes, same order. Yeah, you have made party, na? The respondent. Number 2. Same order. Issue notice so and so. Also call for the case record. Case diary.
Notice may be issued.
Yes, notice be issued through Judicial Police Station. The process you know, through Judicial Police Station routed to the Office of the Registry and the Public Prosecutor. In that case only, we can ask the Public Prosecutor regarding the status of the report or the can make an inquiry regarding the service of notice. So this CD will be called for. Yes,
28-4.
28-4. Okay.
Lordship, before Bihu.
Before we don't have any dates of before Bihu. See the condition, how can we fix? Bihu to wala kothay ase.
May it please, your lordship. Matter is of child marriage, my lord. Petitioner, my lord, is the father of the girl. The FIR, my lord, is at
Petitioner is the father of the girl
father of the
or boy.
girl. FIR is at page number 14, my lord. It has been alleged, my lord, that that one Afsar Ali Mondal from one informed that one Afsar Ali Mondal married one minor girl, namely Shahnaz Begum, daughter of Basir Ali. So petitioner is this Basir Ali, my lord.
So he was present at the time of marriage.
Our case is that, my lord, she ran away with that boy. So we had no knowledge and we never had anything to do with the marriage because we refused her request for consummation of her marriage with that boy because she was still a minor. So we had nothing to do. She eloped and got married with that boy. That is our case. I am the father, man, Basir Ali. And the FIR was lodged by one SI, P. Jyotirmoy Das. And as per
But the allegation where the during the arrangement of the marriage, the FIR was lodged or after that?
After. And as per the FIR, my lord, the age of the girl is 17 years at the time of marriage.
So in that case, her husband is also an accused.
Yes, accused. Husband is the main accused and the father of the husband and the father of the girl, both have been made co-accused in the FIR.
The page number 14 is the FIR, my lord.
Yes.
Page number 14, third paragraph.
Hmm.
It is worth mentioning that preliminary investigation revealed that the parents, relative of victim and groom secretly performed their child marriage, flouting the land of the law. This is the matter allegation. In a matter saying it is a case of POXO, my lord. Now, informant is the matter police officer, my lord. So, my lord, we can represent as my lord, amicus may be appointed, my lord.
For whom? Amicus is no use of, I think, amicus. He is simply the lost the FIR.
Yes.
As a responsible police officer.
Yes.
That much only, so you can represent, I think. But if you see the record section 4, definitely not the case of section 4 against the present petitioner particularly.
But child marriage will come.
Child marriage will come. Child marriage will come. Yes, any other prayer from CTB call for?
If your lordship may grant interim protection at this stage, because considering that main allegation that is POXO is not attracted to
POXO may not come, my lord, against.
POXO
POXO may not come.
will not come against him. Heard Mr. S.S. Delanet counsel for the petition. And also heard Mr. R.J. Borba Delanet additional PP appearing on behalf of state respondent. This is an application on section so and so in connection with so and so. It is submitted by Mr. Das that the present accused petitioner is the father of the victim, who allegedly married with a boy at her minor age at the instance of the present petitioner. But the actual fact is that the present petitioner and his family members is no way related in the marriage of their daughter, and she herself fled away from their house and got married with one whom she married.
Yes, and this one, Afsar Ali Mondal.
With one Afsar Ali Mandal, full stop. But he submitted that the section 4 of the POXO is not at all attracted against the present petitioner, and he is ready to cooperate with you. Allow Koediva. Mr. Buradiva insisted to call for the case diary and submitted that in the FI itself, the allegation has been brought that the parents of the victim, that is including the present informant, was very much involved in secretly performing the child marriage of his own daughter. Considering the submission, so and so CDB call for interim to DTO. CD, yes. May, yes, it can be fixed on May. 9th of May. 9th of May. It will be under interim protection. We have also take steps. Oh, no need to take steps. Okay, then. No need to take steps for the respondents, state respondents, and the respondent number 1 and 2, and the learned additional PP will represent both the respondent number 1 and 2. No formal notice is required. Yes.
May it please, your lordship.
Yes.
Actually, there is a 482 applications, and the sections are 22C, 25, and 29 of the NDPS Act. The facts leading to the FIR is that on 8/12/2024, there was a NACA checking conducted, and goods carrier truck was apprehended. And at that time, the NACA party, they could see the driver fleeing. So they recovered the vehicle which was stranded there. And while recovering, they got around 294 cartons of codeine phosphate, which was hidden under one onion bag, onion bags, about 30 bags of onion. So thereafter, the NACA team had seized my RC book also. That is, I am the owner of the vehicle. That is admitted fact. But your lordship will see, thereafter the police has directed to register a case against me, and I have been shown as suspected accused in the FIR, which is at page 18. But the grounds which I am urging here is that first of all, I am a resident of UP.
And the incident happened in Chudaibari, Tripura, Chudaibari at Sribhumi. And secondly, I entered into an agreement with another person, Vinod Kumar, and I have given it for hire on 6/1/2024. And this incident happened on 8/12/2024. So thereafter, I cannot be said to have conscious knowledge or nothing was recovered from me also. So under those circumstances, this section 25, 22C, 29 will not get attracted. So under that circumstance, your lordship may grant me interim because I'm ready to cooperate.
My lord, a track was stopped, my lord, during Naga cycling, my lord. Driver fled away, my lord. Then on suspicion, my lord, track was sick, my lord. Then 44,100 bottles of coffee are recovered, my lord. Now he is the owner of the vehicle, my lord. Whether, my lord, there is his involvement is there or not, that will reveal from the case diary, my lord. Because, my lord, since the driver is fled away, my lord. Because my humble submission, my lord, nobody has been arrested, my lord, so far in this case. So, my lord, let the case diary come, my lord, and we'll examine the case diary, my lord.
And
because this is
moreover,
a
your lordship, the
commercial quantity, my lord.
apprehension is there that when I visit the police thana to take Zimma, I may be arrested. So I have
So
a
that's why Mr. Burwa is submitting that we want to see the what material has been collected by the IO so far. And as you have submitted that though you are the owner, that already hire purchase agreement is there. In the meantime, there may be some progress or may not be also. I don't know, because no one has been arrested in connection with it. Still dead. Driver is also fled away. So what is the line of progress, or what is the investigation on what line that has to be sent? So it is not a
Your
case
Lordship, I would
for
like to-
anticipatory directly. So we have to pay the case tag.
I'd like to submit one decision passed by the apex court also, wherein the court has held that the owner can be arraigned as accused only under two circumstances. First of all, the contraband has to be recovered from me directly from the owner. Secondly, it has to be recovered from his agent.
Now, if you see that driver is an agent,
Section 29 is there.
Not my
section 29 is also there. So
Sir.
I don't know, we don't know. At present, we are not in anything to say whether we are not, before
Let
us
the case
not
diary
today.
come, my lord, after
Because if it is suppose any conspiracy was there, that's why 29 is also there. So we are not at a stage that how can we, there may be, your submission may be correct and he may not be involved in that case. So we are calling for the case diary at present. Yes,
Till
Burwawan?
then, if your lordship please.
No, sorry. Yes, Burwawan, you can take call.
Immediately after vacation, my lord, 24th, my lord.
24. Call for this case.
Obliged.
Before
Yes, Mr.
So for 82 petition, my lord. My lord, FIR is page 13, my lord. Complaint against my lord Parthopatim, Bordole, Salam Ali, Hafizur Rahman and others. They are already released on bail, my lord. My lord, allegation is for illegal and fraudulent activities done by the Aadhaar and enrollment operator Parthopatim Bordole through his station ID 83125. In regard this, my lord, petitioner has no role, my lord. He has no knowledge. He has not done anything, but additionally has been visited to the house of the petitioner. Hence, on apprehension, file this instant petition, my lord. for
Case diary, my lord. Only case diary. Allegations are serious, my lord.
Case is otherwise very serious in nature. I don't know your involvement, how far it is involved you.
My lord,
But
already several petitioner already released from bail.
No, that
arrest,
is
my lord.
after arrest.
One AB petition is there. All are AB petition, my lord.
All AB.
All AB, my lord. So actual, Honorable Parthopatim Bordole, he was the main owner. He has the ID. Through his ID 83125 that
Yes, you have submitted some AB.
all are
But
Whether
all
after
are-
perusing the case diary, my lord.
these are all after perusing the case diary. in fact.
Parthopatim brother Bordole Manadi, he was released after perusing that case diary, madam. That Parthopatim Bordole. AB number 426 of 2024.
Yes.
And he was released after perusing the case diary. Others also.
So all after perusing the case diary, I think.
P number 635/2024, Salam Ali and others, they are released on bail. Interim order is there, but
This
their
feedback
letter-
was by Mr. Justice Robin Foucault, in fact.
Right.
Appropriate bench দিয়া ভালো হবে নাকি better হবে? Appropriate bench, it can be pushed before appropriate bench. All are passed by Mr. Justice Robin Foucault.
In that one, lawsuit court was not available.
Because if suppose without perusal of the case diary, the court finds that there is a ground for releasing him, that may be about one ground, but I think his case is very serious in nature, so in my
Already
opinion,
done.
without perusal, we cannot pass any order.
I'm already, after taking the biometric mallet, that Aadhaar card already issued through this.
No,
ID
these
of
are all, these are submission from your side, but here before prosecution.
No, my lord, in AB number 426, there is.
Then
Submission.
we may pass an order before appropriate bench.
But the appropriate is not available.
No,
It is
available. He is
my lord,
available.
but
He
this
is
matter
available.
is the connected matter, my lord, already disposed of by some other bench, my lord.
3 matters has already been disposed of
Three
by
or four
Mr.
mat-
Foucault.
four AB. madam.
Yes, 4 ABs are already.
Still before appropriate bench, my lord.
If you fix it before, if you think that without perusal of the case diary, these orders have been passed, then I don't know, but case is very serious in nature otherwise. It's a scam, in fact, scam. Scam is going on.
Then matter may be fixed on appropriate bench.
Appropriate bench. Okay.
Court is available.
List next week for him, or next week. List before appropriate bench on the next week. Next week we are listing it before appropriate bench. List before next week.
Problem.
67 of the supplementary list.
Yes.
Lordship, the 67, 68 lordships, the same affair and the item number 40 lordship. The
Item number
40 lordship.
40. They are connected with 40.
Lordship.
40, we have not received the case diary, my lord.
That's it.
Huh? No, that is submitted, my lord.
The direction of the
40 charges submitted.
same affair lordship.
Simla PS case number 89, my lord.
Then your case also such is submitted.
Lordship. I have to the
Matter in practice already. 40 yes, tell us the case.
Charges number, my lord, 11/2025.
Today's
Date
59 days.
22/3/2025.
20?
22/3/2025.
Today's 59 days in item. number-
Cases of 60 days offense.
Oh, yes, Lord. 59 days.
Immediately, why don't you file an application? Rather, you could have withdrawn if you had any knowledge regarding the submission of the charge sheet. You could have very well approached before us, for withdrawal, we could have passed the order. Okay. That's the plea of default bail is, you cannot take now at this stage, is already charged sheeted. So 40, 67 and 68, all will be disposed of. CS number is same, CS 11 only 2025 dated 22, no, 22/3/2025. Same. So all will be disposed.
Give doubles.
41 and 42.
Yeah, please, your lordship.
48.
Here, on the last occasion, lordship was asking me about the Vihan Kumar. I have the judgment, lordship. I am not at all on the merit of this case. I am
Exclusively 47.
47. So Vihan, lordship may kindly see page number, para number 14, page number 23.
Para, you are insisting, para number?
Number 14, 14, page number 23, lordship.
Yes.
May I just read it out, lordship? It's a long paragraph. I'm going little bit slowly. Thus, the requirement of informing a person arrested of the ground of arrest is not a formality, but a mandatory constitutional requirement. Article 22 is included in Part 3 of the Constitution under the heading of fundamental rights. Thus, it is the fundamental right of every person arrested and detained in custody to be informed of the grounds of arrest as soon as possible. If the grounds of arrest are not informed as soon as may be after the arrest, it would amount to a violation of fundamental rights of the arrestee granted under Article 22(1). It will also amount to depriving the arrestee of his liberty. The reason is that, as provided in Article 21, no person can be deprived of his liberty except in accordance with the procedure established by law. The procedure established by law also includes what is provided in Article 22, subclause 1. Therefore, when a person is arrested without a warrant and the grounds of arrest are not informed to him, as soon as may be after the arrest, it will amount to violation of his fundamental right guaranteed under Article 21 as well. In a given case, if the mandate of Article 22 is not followed while arresting a person or after arresting a person, it will also violate fundamental right to liberty granted under Article 21, and the arrest will be rendered illegal on failure to comply with the requirement of informing the grounds of arrest as soon as may be after the arrest. The arrest is vitiated. Once the arrest is held to be vitiated, the person cannot remain in custody even for a second. Now, Lordship may kindly see, in the coordinating bench, the judgment has been passed by our own High Court. It was a commercial quantity. And here, it is an intermediary quantity.
It's an intermediate.
Yes, Lordship. Today it is 43 days, I am behind the bar, Lordship.
Question is that if 47 has to be considered, my lord, then other factor will not come, my lord. Whether it is
No.
commercial or intermediate, my lord, that will not
That is,
come.
that is a different issue, but I am submitting. That will not come. That is, my brother is correct. That will
Otherwise,
not-
you are
that
in
will not come.
custody since 47 days.
I am today, Lordship, I am behind the bar for 43 days. Another 17 days, my default bail will be over. So, Lordship, I will pray that considering 47 and considering
You
this
have
judgment.
you have annexed your thing this
Yes, yes, I have annexed. Annexion
notice.
number 3, Lordship will kindly see.
Page.
Page will be
18.
19, Lordship.
19.
And if I just add one line, in the order that has been passed, Lordship will kindly see, in the order that has been passed by our coordinating bench, Lordship, the same notice has been pasted as replica. Same thing is written down there, and the court has come to a conclusion that if these wordings are used, then there is no information to the arrestee. The ground of arrest are not at all clear. So I would pray Lordship may kindly grant us bail on this ground itself.
Both 41
and
42 are for same out of same FIR.
Same FIR, Lordship.
And
Same.
the length of detention is also
Is also
other
same.
way.
Arrested on the same day, Lordship.
41 and 42.
Deployed, Lordship.
This two will also go to legal.
Yes.
My lord, since in this case, my lord, case diary not received, my lord. So, my lord, my submission.
Otherwise, case diary was also fixed for. No?
So,
Yes,
case
yes.
diary call for, my lord.
Case there is not required, Lordship, because I am on the fundamental principle of law, Lordship.
Into 41 or 40.
I am absolutely not on merit, I am on the fundamental principle of law.
47 I got same. Both 41 and 42.
I am deployed, Lordship.
Just keep this one.
43.
Yes,
Item number 43, my lord, he is already on interim, my lord. But when the person to that order, my lord, whether he is appeared or not, my lord, this is not clear from the case diary, my lord.
Appeared.
So, my lord,
When his statement is not
not
available.
there, my lord, case diary also not up to date, my lord. So, we have to call for the up to date case diary.
As per your instructions, your petitioner already appeared.
Appeared.
CD, last entry in the CD is still.
May I purely civil nature? He is on merely attesting witness.
3/1/2025.
3/1/25.
25.
Your interim was on 24/1.
Yes.
Interim was on 24/1. 3/1 is the last entry. Same order liquidable as per instructions he appeared, but no statement is available in the case record, and accordingly, Mr. Burwa, the learned additional PP, insisted to call for the updated case diary. Return the same, call for the updated case diary.
9/5, my lord.
9/5, list accordingly on 9/5. Till next date of listing, interim be continued. It will be continued till next day. Okay, you will be under interim protection and do one thing, if you take instruction, proper instruction from your client. If he has not appeared, suppose your interim will be extended to interim, he can appear still and can record his statement. Otherwise, it will be a violation of the order of the conditional bail order.
44.
Last occasion also none appeared. Do you have this case diary? No.
Case diary not received, my lord.
Interim was granted on 29/1/2025. And the next date was 3/7/3. None appears on call for the petitioner. But Mr. R.J. Burwari, Land Council for the state response number 1. List accordingly after 2 weeks. Left 1 week. After 1 week.
45.
Your Lordship. 45, 46, 47, and 48 are same. And the accused person already appeared before the.
In these cases also, my lord, case diary is not approved, my lord.
As per your instruction, 45, 46, 47, 48, all appeared?
Yes, on 17/3/2025, before SDPO Junai, along with documents, Lordship.
On, as per you, 17/3.
17/3.
Order of interim was on 10/3.
10/3.
Order of interim was on 10/3, same order, appeared on as submitted by Mr. Fukon, all the deputy petitioner petition appeared on 17/3, and his statement is also recorded. However, it is submitted by Mr. Burwa that your case last entry you just see.
My lord, it's 5/8/2024, my lord.
Last entry is 5/8/24. Updated case diary be called for interim be extended, wherein can be fixed.
8/5, my lord.
Right. Your interim, we extending your interim 8/5, and if in this period, if you have any information regarding this.
Accused person, petitioner number 45, 46, 47, 48, all appeared along with necessary documents, Lordship.
Oh, we have already.
Yes.
Your date is on 17/3, you have appeared. Your interim will be extended. We are calling for the updated one.
Okay. Apply.
Matters for admission. Item 35.
Please, Your Lordship. Lordship, kindly the matter may be passed over for the time being. My senior will be appearing in this case.
Okay, but time being, I don't know. You are for the other side?
Yes, sir.
Okay. Okay, for that.
37.
May I please, Your Lordship, my lord, this is a quashing proceeding of POXO and rape case. My lord, and the accused is also a minor. The victim is also a minor. If parents, the father being the police officer with his colleagues, forcibly got her married with the boy on gunpoint, and she is a prior to that she is a HBI positive, my lord.
HIV positive.
HIV positive. My lord, on that regards, my lord, the honorable court twice ordered for a report from the lower court, but it has not come till now. Twice reminders sent. I've seen the, my lord, the office note also. It is twice office note is there of dated 20 February and 10th of March. Twice sent the reminder, but it is not. It is coming here now. Both are remaining.
So from the trial court, it is not it has not come.
It has not, no report has come. Kindly have a look at the order, my lord, dated, my lord, 11/2, my lord.
No, whether this petitioner presently where he is now, he's in jail or bail?
Sure, because the interior area mobile connection is not much available. I am not in touch with him.
No, I am asking, you're
Yes.
praying for quashing of the entire petition.
Yes.
One hand, on the other hand, you are saying that he was a juvenile.
Yes.
So that's why I'm asking, where is he now?
Exactly, I don't know the latest position, my lord, because I am not in touch because of non
You are appearing for the other side?
father and mother of the victim. Father and mother of the victim. my lord.
Respondent number 8 and 9.
They are the parents of the victim girls. All police in connivance with the father and mother, they have done the marriage.
So you are representing all other respondents, otherwise? 1, 2, 3, 4, 5, 6. 6 is the 6 is also an investigating officer, but your name is there.
Yes, my lord, because I have serious allegation against them. My lord. Serious allegation. They are involved in this gunpoint marriage, my lord.
Then, my lord, his
With the
allegation was
HIV positive the girl, my lord.
My
That also
name-
minor.
He is involved in the marriage.
Yes,
Otherwise, he is a police officer.
Yes, ma'am. My father is also a police officer. He is always works with the SP of Karimganj, my lord. This is
He is also a police officer.
Yes, that is very shocking, my lord. I have. It will shock your lordship conscience, my lord. What is happening and what happened, my lord.
The notice may be issued to him, my lord, because he's been named by, he's been made party by name, my lord. Respondent number
No,
six.
otherwise, you are representing all the petitioner.
Not only, my lord, who have been, my lord, named by, my lord, official, in official name, my lord. Suppose OC and all.
But one observation was made by this court on while passing the order on 11/2/2025, in fact.
Your lordship can at that stage I do not.
That till inquiry directed is completed, a further proceedings so and so was stayed, and it was in para number 10 that as regards the other respondent, this court is of considered opinion at this stage that they may not be necessary for the consideration of instant criminal petition. Hence, no notices need to be issued. So that is the observation of the court till the inquiry report is received. But inquiry report is still awaited. Urgent reminder has already been issued to the additional session judge Karimganj on Iman for transmitting the scan copy of the case record special. So, of what is office? Actually, the report was called for, na?
Yes, but kindly see the office note dated 20 February, my lord, and 20 February and 10th March.
Well, surprisingly, it is scan copy only. But you want
No,
the
no,
report.
report is called for, my lord. The report is there. Kindly have a look at the office, my lord, note dated 20 February, my lord. And no, my lord, office note, my lord, office.
Yes, we are seeing an office note only.
10th of March, perhaps, my lord. At first, I have seen the report was called for.
But subsequently, of this scan copy is
Yes,
there only.
yes, subsequently
That is
scan.
why scan copy. Okay. Scan copy may be called for, but at this stage, we want the report regarding the juvenility.
Yes, exactly. The first import.
So in the first order, it has been reflected. Huh?
Reflected. The second order also, my lord. Second order also, my lord, to issue reminder. Order dated, my lord, 27th February.
Heard Mr. A.K. Talukdar, Dilane counsel for the petition. And also heard Mr. R.J. Borwa, Dilane additional PP, appearing on behalf of state respondents Vidyoka. And Mr. A. Amin, appearing for the respondent number 8 and 9. From office note dated 26/3/2025, it is seen that the report called from the additional session judge FTC Karimganj on 20/02/2025 has not been received by the section. And the LCR is also not received in spite of issuance of urgent reminder. It is submitted by Mr. Talukdar that by order dated 11/2/2025, the report was called for from the learned additional session judge FTC Karimganj for regarding the juvenility of the present petitioner. But till that, the report is not received by this court, by the registry.
My lord, next order 27 February, ma'am.
Next, but after hearing the submission made by learned counsel for the both sides, it is seen that the claim is made by the petitioner side that he was a juvenile at the relevant time of incident, and accordingly, the court directed the learned trial court below to make an inquiry regarding the juvenility of the present petitioner, but till that there is no report received from the office of the additional session judge FTC Karimganj. In view of this, the court is hereby, this concerned court is hereby directed to make an inquiry immediately and immediately as to whether the petitioner was a juvenile at the relevant time of incident, and to submit report accordingly on or before the next date of listing. Further, the court is directed to furnish the scan copy of the case record before the registry without on registry. Registry will do the needful in issuing reminder in respect issue reminder. List accordingly. It may take some time for this investigation because
Inquiry is conducted already, my lord. As per my information, yes, conducted it.
Already conducted.
Yes.
If it has already been conducted, is very good, then report may be called for. Report, we are calling for the report. Yes, Purva, when it can be called for otherwise.
After vacation.
After vacation, no? That maybe registry may fix a date accordingly.
A date kindly mix, otherwise my lord, it is very difficult to get listed.
If you insist for that, then it will go up to May. We don't have any date.
My lord, as per my instruction.
Whatever, we will go up to May, it may. That's why we are saying that after vacation, if the court registry finds any date, then it will be fixed. Otherwise, we can fix it on 6th of May.
It may not be listed even in May also, my lord, because we have the experience.
6th of May. Is your problem.
38.
Obliged.
May I please note? Let's say this matter maybe come up any other day, madam. My senior will appear in this matter.
Now, see, other day will after Bihu only. We cannot fix date also here.
Interim may be continued. There is
interim is there. Item number 38 at the request made by the learned counsel for the petitioner. List the matter after Bihu vacation. As on a date to be fixed by the registry until next date of listing, interim be continued. Okay.
39.
In this matter, on the last occasion, report was called for.
Report of received, my lord, today.
Report received.
Zimmer is not received, my lord. Zimmer report.
Report is not received.
Sometime maybe not.
What kind of Jimma? It's a
It's
vehicle.
Erica nuts.
Erica nuts.
And it's been almost a year since it has been in custody.
Now see, but report has to be accompanied with the that FSL report also. It is also required. Whether it's a fit for human consumption, that report has to be there. I heard MSP Boda, the learned counsel for the petitioner, and also heard. So why you have taken so? I mean, it was last date of entry was on 17/3.
On that day also report was not available. Therefore, the matter has been fixed for
So
today.
after 10-11 days, where you have taken the date, it could have been either after Bihud and it would have been different. Otherwise, issue reminder political. Further, the additional PP is hereby asked to make personal communication with the concerned IO to get the report. To get the report list accordingly. Yes, after Bihu any date.
15.
15. 15 is a holiday or what?
Holiday.
15.
15 April.
High Court holiday only. 15.
We are not having holiday, I think.
May 1st. Worship, can it be after Bihu?
After 2nd of May. Second.
For orders, item 51.
None appears on for, you are here. Acha, acha.
My lord, there is an IA, my lord, for delay of 414 days in filing the criminal case.
You have not issued notice?
Um,
Notice
my
you have
lord,
not issued?
The opposite party has already appeared.
Appeared?
Yes. His name has been also shown.
Already appeared?
Yes.
Already. Chairman. What are you saying?
Their name has been shown, my lord, in the court list.
Hmm. Otherwise, suppose 30, 40, 50 days was okay, but 400 days is quite a
My lord, kindly see
quite
my
a long delay.
kindly see, my lord, there are 5.
No, whatever. 400 is a
My
long
lord,
delay. in
only,
fact.
my lord, the anxiety is, my lord, the court below directed 5,000 for the wife and 3,000 for each for 2 sides, my lord, 2 daughters. And both the daughters, my lord, from the very initial, my lord, they are, my lord, with the husband. Still they are living with the husband. And my lord, the 5,000 for the wife, my lord, he will pay, my lord, and he is paying regularly, my lord.
So we could not entertain your petition. Delay is still there. No?
Yes, my lord. That
So
is
fact
why
we
delay
cannot
is
hear.
cost, my lord. My lord, he has been paying regularly for the wife, my lord.
So why he has been paying regularly for the why days delay?
Delay, my lord, he assumed that, my lord, 3,000 each for 2 sides, my lord, that has not been paid, my lord. And when the court has issued NBWA against the petitioner and he was arrested, he was detained, and thereafter, my lord, after coming from jail, my lord, he approached this court, my lord, to waive the, my lord, only 6,000, which has been paid for.
No, why delay is there? That's what I'm asking.
That is why, my lord.
Why?
My lord, delay is, my lord, he assumed that he has not to be paid. He has not paid. He has
The
not been
NBW
paid
was
to the-
issued.
paid
He has
to the-
done.
Paid to the, my lord, 2 sides, my lord. Because the 2 sides, they are living with the husband, my lord, with the present petitioner. But he was paying regularly 5,000 for his wife, my lord, the first party. And my lord, not being paid 6,000, my lord, the NBWA issued against the petitioner. And accordingly, he was arrested. And my lord, after coming from jail, my lord, he approached this court. Still, my lord, he is paying regularly. At the time of jail, my lord, when he was detained, my lord, at that time, the family members of the petitioner, my
So
lord,
you are
paid
aggrieved by which order?
16,000.
You are aggrieved by which order?
My lord,
Why this revision petition?
waive that part, my lord, the payment which has to be paid, my lord, for 2 daughters, 3,000, my lord, 6,000.
Now see
that has
for
to be
that
waived,
reason,
my lord.
for that reason, you can file a petition for alteration or modification of the order
Yes,
also.
my lord, yes.
So why don't you approach it in a trial court below? You can approach it in a trial court below with a fresh petition that the girls are with me, this situation or circumstances has already been changed. They are with us. You can adduce.
Second is the,
Now,
my
how
lord,
can we don't have any evidence to record, we don't have anything before us.
my lord, he
Only on your submission, how can we record? How can we pass the order in a revision petition? Because they are not before us. We at this stage, we cannot pass any order. Delay is also 400. I don't know from where it has been calculated. 400 means which date?
My lord, from the date of judgment, my lord.
Date of judgment is on?
Date of judgment, my lord.
Anyway, what do petition?
8/6/2022.
8/6?
2022.
22.
2.
Long delay then. Better, I think you can approach the court below. That will be best option, I think, for, because there is change of circumstances is there, everything is there.
These, my lord, this has been taken as a plea in the trial proceeding, my lord, but that court has not considered the same. My lord.
And what to do? We cannot record evidence now. And that apart, also two advocates are already being entered into evidence. So without hearing them, it should not be proper, I think. If you can inform them, I don't know. Can you? One Mr. R. Ali is there and H.A. Ahmed is there.
The court, my lord, he is not available.
Mr. Ali is not there.
On last occasion, my lord, he was, on last occasion, my lord, it was.
Last occasion, it doesn't.
He was, my lord, present.
Shortly দিয়ে কারণ দিছিল এইটো এনেই procedure মনে
last
রাখে shortly দিটো লাভ নাই.
It was
It
left
was
over.
the last listed on 24.
It was left over, my lord.
Then again 20, 27, 25 5 দিনৰ ভিতৰত ডেট দিলে কেনেকে হ'ব?
Now this matter was left over, my lord, last occasion.
কেনেকে ডেট কি কৰিব আপুনি? নাহিব এনেও. Heard Mr. S.A. Ahmed, the learned counsel for the petition. None appears on call for the respondent, though the name of two learned advocates are being shown in the cause list. Let the matter be listed after Bihu vacation? After Bihu?
My lord,
Yes.
my lord, only, my lord, the revision is not yet numbered.
Not yet
Only
numbered,
this-
what to do?
This IA is for.
That's why I just ask you if Mr.
Let it
Ali
come,
is
my lord,
there,
first
if Mr. Ali is there, we can dispose of the
My lord,
petition.
let it come first week of the April, my lord.
First week of April?
Yes.
Who is first of April? Before Bihu? We
Yes.
don't have any days before.
It's
It
not-
will be
it's
after
my
Bihu
lord,
only. After Bihu
Only
only.
the delay part, my lord.
Now see, we don't have any dates. What to do? These are all be motions matter, more lots of matters will be fixed. Delay part koi do. 22 for side koi do. 22 for. 20. Many matters. If you can search for Ahmed also or Ali also, it's okay.
Two dates set, my lord.
Yes, you can.
Then
If
I-
they are available, I don't know they are available or not. If you have any contact number, you can contact. Yes, okay, time being I have keep.
After 5 minutes.
After 5 minutes, okay.
Obliging.
52 and 53.
May it please your lordship, kindly the matter be taken up after Bihu vacation. For hearing.
After Bihu vacation,
Yes, lordship.
both 52 and 53. You're for the 53. These are all connected or these are why? These are connected matters, no? I mean, two appeals are out of same judgment. I think so. And a request made by the learned counsel for the appellant. List the matters after Bihu vacation as on a date to be fixed by the registry. Okay, it will be listed after Bihu.
Oblige lordship.
54.
May it please your lordship.
Why it is in order column?
For the IA, but then IA is not listed. On the last
know.
day today, it was listed for the IA. But in the cause list, the IA is not shown. I don't know whether the record IA is there or not.
I is not listed.
Today was fixed otherwise only for consideration of the IA matter. Because on the last occasion, Mr. A. Ahmed was also appointed as amicus in the matter.
I am appearing on behalf of Azad Ahmed, Mr. Azad. I'm my custody.
The IA fell to Asen.
Not listed, but the file is here.
File is here, but it's not listed.
Not listed. Case under 376. Initially, charge was framed under 366 and 376. Subsequently, 366 was repeated. 376 was convicted. And the sole issue here is, madam, if the prosecution is otherwise unable to prove its case beyond reasonable doubt, can the court rely only on the suggestions given by the defense counsel to hold the accused guilty? This was a case where the
Yes, what was the term of
10 years, madam.
10 years. Mr. Borwa, do you have you filed your objection here? You have to file. Or otherwise we have received the case. I mean,
Case records are available.
LCR received, madam.
On the last occasion, actually, opportunity was also granted to file the
Hmm.
objection.
Normally, last occasion, my lord, only.
We don't have these things before us now.
I didn't.
A. Ahmed is appointed as an amicus, is here only. Memo of appeal list accordingly. Learned counsel for the applicant direct to find the memo of appeal. To find the copy of petition, the petition of the speakers of the learned amicus.
There's an order in the IA also. Can you see that?
I think. Oh, there's nothing, only trial court, after receipt of the trial court record, that was only in the IA.
Last day's order is.
Last date order in IA is 30/10/2024.
No, there's another order should have been there on 5/3, madam. 5/3/25.
5/3.
Because
Now,
this matter was-
5/3 is in most probably here. 5/3, if you can, talking about 5/3, it is a criminal appeal.
Criminal
only.
appeal. On that day, IA was also there, madam. Perhaps some inadvertently may have been left out because on that day, there was also an order in the IA. Because on the prosecution had not filed their objection, so a time was given to the prosecution to file the.
But it's not here anything.
Then in that case, my lord may give an order, pass an order today, my lord, then they can file an objection by the next date, my lord.
File an objection, this is 10 years of conviction.
My lord.
Otherwise, it's not here, anything here. As you have submitted, 5/3 order is there, just here. Mr. S. Nawaz is heard and so. Notice issued to the respondent has been received back with an adjournment deceased. And then accordingly, each Ahmed was appointed as an amicus. And learned counsel for the applicant is directed to furnish the memo of appeal as well as the application for suspension of sentence, along with the annexures to the amicus. That much is there. List accordingly on 28th of March. The registry is directed to furnish the copy of deposition of exhibits and others to the amicus curiae. That much is the order. But this time is also, I mean, it's not here anything otherwise. Anyway, if you can submit from the record, I don't know, otherwise you may.
Will peruse the my lord scan copy, my lord. Not today, my lord, but.
Not today.
Today will peruse, my lord, and lordship may granted some time, my lord, we will file our objection.
And Mr. Ahmed, you are also going to file any objection here? In IA especially? It's up to you. You can file or otherwise your case is that only basing on the suggestion only.
Suggestions, because what had happened, the suggestion was put to the witness that there was
Who
a.
passed the order? Where is the conviction order? Judgment was passed by whom?
Session, my lord, Session Judge Kamrup, Amin Gaur, my lord.
Session Judge Kamrup, Amin Gaur.
Because an allegation was that we went together and so I abducted her and then raped her. And then it was proved that the victim and her friend had voluntarily come with me to that place. So 366 was, that part was not proved. And a suggestion was put in from our side that whatever relationship took place between you, between the two of them, that was a consensual relationship. So the taking on that suggestion as proof of the fact that a sexual relationship took place on that day, I was convicted. So that is the issue which is to be decided, that only whether, and if the prosecution is otherwise not able to prove its case beyond reasonable doubt, whether the court can take the assistance of the suggestions given by the defense and convict. That is the issue to be decided.
Yes, I can understand. I heard Mr. S. Nawaz in counsel. Mr. Sharma is also here.
Yes, madam.
Your name is here one first. Anyway, now before us, Nawaz is here.
Yes.
Heard Mr. S. Nawaz in counsel for the applicant and also heard Mr. R.J. Burba, the learned additional PP appearing on behalf of state respondent and Mr. A. Ahmed.
I'm appearing on behalf of Azad Ahmed. Myself, A. Ahmed.
You are A. Ahmed and you are appearing for the other A. Ahmed. Anyway, Ahmed for the respondent informant. LCR has already been received. However, it is submitted by Mr. Purva that the prosecution and the prosecution needs, he needs some more time to file their written objection. Mr. Ahmed also submitted that he may also file the written objection to that regard. Let the matter be listed when it can be listed.
13/5. One.
Sorry, too long, my lord. 28th if possible, my lord, 28th.
28, no, will require some time, my lord. 28 also April.
28th April, not March, 28th April.
I'm sorry, my
March
lord.
or 9,
28, my lord, 28. 28. Good.
28 April. Enabling the respondent side to file the written objection. We will try to hear the matter on the
Madam.
next date. How long he is in custody now?
Since the date of judgment, my lord, 7 months, my lord, since 29/8.
Our main order criminal appeal লিখিব hard so and so করে দিব list matter may be listed for it can be hard finally hard also. I think appeal is otherwise ready also.
It will be listed on that day, my lord, if your
Yes,
lordship.
let be listed on 28/4/2004 final hearing. Okay, we'll see to it.
Deeply.
আমার এটা কোনটা আছে? আপুনি তাৰপৰা দেখিছে ন মই কি মাৰ্ক কৰি আছো আমি তাৰপৰা মোক দেখিছে মই 53 মাৰ্ক কৰি থাকা
55.
As per office note dated 26/3/2025, where service report upon respondent number, your worship.
service report is still awaited.
Dated, your worship.
You have received this scan copy here?
Not yet.
Awaited. Scan copy is also.
What's the long?
One amicus was already appointed here. Amicus এটার নাম দিয়ে থোৱা আছে যে কোন পাই বলি তুই amicus কি amicus আমি 50 কিমান লৈ
55.
ও URMS Medi A Medi first MSA Medi, the as per office note dated M Medi, as full stop as per office note dated 26/3/2025. The service on respondent number 2 and the scan copy is awaited. Registry is hereby directed to issue reminder for the scan copy. List the matter accordingly after vacation.
Publicity.
57. This is complete and here has also been received.
No one has appeared. None appears on call for the petition. However, from the office note, it is seen that the service is also completed and the LCR has also been received. List the matter accordingly after 2 weeks.
58, 59.
In the morning hours, it was a fix now. So in the morning hours, most probably you know the position. For 58, time was prayed, in fact.
This
It
note is
was.
ready, ready for hearing, my lord. This note is.
Otherwise, it's ready for hearing. Why it is in order column? Can you tell us? Oh, no. It is in order column because of pending of one eye. I
One
think.
eye.
So your matter is also we are fixing 1 week again. After 1 week, okay?
1 week.
Otherwise, it's a hearing matter. But these two matters are connected. That's why I'm asking. Out of same judgment?
My lord.
Same judgment. So we're listing it after 1 week. List after 1 week.
60.
Why it is in order column? We are not supposed, we are not going to hear the matter. Why it is in order column? You are already entered into appearance.
Lordship, I am appealing for respondent number 2. Yesterday we filed a color number, Lordship.
Yesterday you have already filed your
We
work.
will file affidavit, Lordship. May you please after.
How many respondents are respondent? One is state.
One is state, another one is.
You are one. And Mr. Diula, Iran counsel for the petition.
We have interim suspension should continue.
Interim was there.
Yes, suspension of the proceeding.
No, whatever, interim was there earlier. This one is interim was on 17/2.
Lordship, it was on 17/2. It is still next returnable.
Returnable. Also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent. And Mr. K.K. Hendik, appearing for the respondent number 2. It is submitted by Mr. Hendik that he has filed his wakalatnama today and needs some more time to file the objection. Prayer allowed, please the matter accordingly after BU vacation. After BU vacation, as on a date to be fixed by the registry. Interim be continued till next date of listing. Okay.
Okay.
62.
May I please, Lordship? Lordship, the office note dated 26/3, and it was routed to the district judge Jorhat, my lord, but the service is still awaited, my lord.
Lordship, I am appealing for it.
She is appealing for.
Yes,
Oh.
legal is covered.
In that case, my lord, I'll play a short date, my lord, because I'm seeking an interim order in this case, my lord. On the last occasion, my lord, there was an observation by the court that on appearance of the respondent number 2, my lord, the interim would be considered, my lord.
Yes, what is the thing?
Question is that this is substitute case, my lord. So, my lord, LCR, whether call for or not, my lord, LCR already called for.
Call for, my lord, that has not.
LCR not received, my lord.
Answer is awaited.
LCR, my lord. And matter can be hard and dispose of, my lord, after perusing of the LCR, my lord. Since the opposite party has also appeared.
You're going to file any objection here or verbal submission will this?
Yesterday only. Lordship.
Yesterday only. Objection will be filed by you.
I see. If necessary.
If necessary, okay. Now see, Mr. Tiwari, we don't have any short dates. That is our
Immediately
problem.
after the vacation, immediately after the, whichever is convenient to your lordship.
Obviously, immediately after BU vacation.
Question is, the LCR has to receive, my lord. So today LCR not received.
No, today is not.
Maybe assumed.
So we are not fixing any date immediately after BU vacation. If the LCR receive, then it will be taken up. Your interim in connection with for the stay.
Yes, madam.
What is the stage of the case at present?
My lord, the copy would be furnished, madam, on the next date, madam.
Not yet. The trial is not has been commenced. Heard Mr. A. Tiwari, the learned counsel for the petitioner, and also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent, and MS
R.B. Bora.
R.B. Bora, the appearing for the respondent number 2. MS R.B. Bora submitted that she has received the notice on yesterday, and wakalatnama you have filed.
Brief from the legal services authority.
Legal service orders. Oh, acha. You're for the legal aid council. MS Bora appearing for issuance as a legal aid council. Likhibo na? Heard MS RP Bora, legal aid council appearing for the respondent number 2, and who received the brief from the district legal services authority on yesterday, and hence needs some more time to file their objection if necessary. from the office note, it is also sent that the scanned copy of the LCI is also awaited. Issue reminder, registry will do the needful. List the matter accordingly after view vacation on a date to be fixed by the registry. And endeavor shall be made to dispose of the matter and the admission stage. It will be fixed in the admission column. You'll try to. So,
Deeply obliged.
63.
I for lordship, condition of delay lordship.
what was the delay? You tell us.
91 days lordship.
91 days. Yes, Borwa, any objection?
No, my lord, let them notice go, my lord. Opposite party has been made party with them.
Or submit party? Acha. Oh, opposite party, there are 1, 2, 3, 4, 5, 6. 6 numbers of opposite parties. Issue notice go. This is an application and section so and so issue notice to the respondents through registered AD and as usual process. Stop. Also call for the, this is a case of charge sheeted one or what kind of thing?
Against the order lordship.
Against the order.
Yes, sir.
LCR will be read.
Conviction, my lord. Conviction.
Also order of conviction.
My lord, let my lord opposite party appear, my lord. After that, my lord, if my lord section 5 is not allowed, my lord, his appeal will go, my lord.
Have you explained your delay in IA?
Yes, lordship.
Issue notice for it. List accordingly after view. After view vacation, we are listing the case. In the meantime, within 2-3 days, you take steps for the respondents. If it was no formal notice is required to be served on the state respondent.
69.
This matter may be passed over for the day.
Huh?
Kindly, this matter may be passed over for the day.
For a day,
Yes, Lordship.
they will be, go after view.
Lordship.
The request made by the learned counsel for the petitioner, appellant, sorry, list the matter after view vacation as on a date to be fixed by the registry.
Deeply.
Why is in order column?
Lordship, our notice was issued against respondent number 2.
Still awaited?
Yes, Lordship.
Further from the office note dated 26/3/2025, it is seen that the services still awaited for the respondent number 2. List accordingly. Okay.
Yes, Lordship.
17.
Lordship, please to issue notice the other day, especially wanted instructions. I think the CD has also come regarding the bank. I said CD. But so my only question is that why should the bank account be freezed?
It was dealt by Mr. Das. He is here.
My lord.
It was date for case was fixed on 26/3. Last.
Yes, my lord. Because case diary was called for, my lord. And my lord, there is the opposite party number 2, my lord. So his presence would be necessary in this.
Why lordship for defreezing the bank guarantee? I mean the bank account. I have to pay my dues by today. Why is the freezing of the bank?
Actually, on the last occasion, there was, as per the petitioner's case, his 2 freeze, how many accounts were freezed?
One account.
His account was freezed, in fact. So they are basically stretching up for the defreezing of the account. So on the last occasion, Mr. Das was there. He submitted that CD was called for. In the meantime, if report comes from the IO whether this freezing of those is still required or not, or this kind of thing. So I don't know, you may not be aware, but
I am not aware, my lord. Then, my lord, I take instruction, my lord. If possible, my lord, over phone only, my lord. So, lord, may fix a salt test, my lord.
But
Because case diary we have received, my lord.
otherwise case diary you have
Case diary
received.
we have.
I mean, case diary.
And at best, it can be fixed on Tuesday, I think.
Yes, not Tuesday, my lord. It will be Wednesday. my lord.
Wednesday.
But
Wednesday
lordship,
again.
my problem.
Wednesday is 2/4. Yes.
Lordship, my problem is what do I do? How do I pay my dues?
What to do? It's a case is against you.
Only the bank account to be defreezed, let it be
That is the
defreezed.
main issue. Your bank account has been freezed. That is the main
Why?
issue. If it defreezed.
It has nothing to do with my fraud. My bank account has not committed fraud, Lordship. Bank account is
Now
absolutely.
see, the allegation is that the entire money is deposited in your account.
Yes.
This is the amount which
Yes.
alleged to have been there was some allegation of fraud and all. That's
I'll
why.
give the latest statement that money is no longer there in my account. So freezing my bank account wouldn't do any serve any purpose.
Yes, Mr. Burwa, if you can, just a second, if the report is available or if you can submit, we can hear the matter. Otherwise, it will be fixed on Wednesday.
Let it be on Wednesday, my lord. I tried to obtain verbal instruction, my lord. That whether my lord further freezing is required or not.
This is absolutely.
Because I am not aware of the last date order, my lord.
Last date order was there was a freezing of account where it was the money was deposited in his account and accordingly that order, the account was freezed on a prayer made by the IO, whatever. So now as an interim measure or interim prayer, she is seeking for defreezing of the account. That is the main issue and the DAS was there. So CD was called for accordingly, Joe, it was a very short date, but we fixed for the short date. And in the meantime, he was supposed to take any instructions or the report from the IO regarding the defreezing of the swens because report is to be called for because it has been freezed. That is the reason.
The DAS is not available, my lord. So I have to
Freeze
take
is
the
not available.
responsibility, my lord. That's what I have.
Take it on Wednesday and otherwise. Otherwise, we are not in a position to give any dates before Bihu. But however, your condition we see as you have submitted. Based on Wednesday corridor.
My statement would reflect whether I've received or not. I mean, the
Mr.
account,
Burwa, I don't know if he is in a position, I cannot say.
my
But
statement would reflect. The bank cannot do anything to my statement. That statement would show because this is not today's statement. This is statement of February. So that is what they need, not my account. So I don't see any purpose for the purpose. It's just lots of vindictiveness and some, I don't know, they have some issues. I mean, it's more than it meets the eye, actually, what is happening, which I would not like to say, but that's what has happened. Wednesday, then, I'll not.
ask Mr. Das also, he was aware of, in fact.
Leaders or
KK Das. first.
My father.
He had already left, I think, I don't know.
Father.
Or otherwise, you can make an inquiry through over telephone also. With
He
the
can do it,
concern
but-
IO, if suppose the report is not available. If it is already available, CD is there, then it will go after this one. Otherwise, we are fixing it on Wednesday. This second. List on Wednesday, could you on?
Second.
We'll tackle again.
Yes, yes. Timing 51.
My lord, the conducting advocate is H. Ali, my lord. He
H.
has-
Ali, no, R. Ali.
No, R. Ali, my lord, is senior, but conducting, the clerk is with H. Ali. My lord. He is the conducting advocate.
Acha.
My lord, he already left the court, my lord. And otherwise, my lord.
No,
he
see,
said
that's
that-
what I'm just saying that if it is a question of 30, 40, 50, even 60, 78 days, then matter would have been different, but it's a delay of more than 400 days.
My lord, yes.
So
yes,
that is the question.
correct, my lord.
That is,
My lord, otherwise, he said that regarding the condemnation of delay, he has no objection.
Let him come and
Because-
say, let him come and
Because,
say.
my lord, they have been.
No, let
getting
him come and say.
getting the-
No, whatever, let him come and say, that's what I'm saying. It's a small matter, I also know.
My lord, let it come, my lord, before Bihu, my lord. It's small issue,
Okay,
my
on
lord.
4th.
Yes, 4th.
Only Kivan number is later. 51. List on 444. Okay.
Obliging.
Right. Ask him to come on that day. It's a
Yes,
very
yes,
small
yes.
matter. If they do not have any, and if you have delay, explain the delay, we'll look after it.
Obliging.
I'll go ahead and move to-
35.
Yes, 35.
Please, your lordship. I beg your pardon, my senior could not come.
Huh.
Lordship, this is a criminal
What is
petition
the 35
filed
kilo
against-
balance? Petition.
May it please, your lordship.
So you're going to our
May it please, your lordship. This criminal petition is filed for the quashing of the seizure proceeding case number 1481/2022 that is filed by the complainant against the petitioner. But the initial question is that the petitioner is already being transferred to another post. She was being promoted and then transferred. So in the time when for the second time when the complainant approached the post office for what you say withdrawal of the NSC amount, till then another postmaster was appointed in that place. So because of that there was some delay. So as the petitioner is no longer in that sub postmaster post, so whether this proceeding can be conducted against her, because she is no longer in that post, she is being transferred and promoted.
No, she is an accused here.
No, she was termed as accused here because when the complainant approached the post office, at that time she was the sub postmaster. So she took the initiative. She wrote the letter to the superintendent for further proceeding for the manual encashment of the NSC amount. So on the second time, when the complainant again approached the post office, there was some other postmaster newly appointed because the Alpana Dasgupta, she was being transferred to as the head postmaster of the Karimganj head post office. So she was no longer in that post. So as being the new postmaster, he has to conduct his duty thoroughly. So on that ground, assuming that the earlier postmaster had conducted some mischief or breach of trust, whether 409 is applicable. That was not intentionally done.
But money was subsequently, it was encashed or cashed, it been delivered to the other side or not?
It was not delivered. It was an offline process, Lordship. So the postmaster had written.
No, as you have submitted that
Yes.
at that time, what application was there for NSA, campaign, whatever. I have not gone through anything against record. But she processed it and she was trying this process was there.
Yes, process was there.
In the meantime, she got transferred and promoted.
Okay.
And now this second subsequent, the postmaster or sub postmaster did it. Now I'm saying that what about the money? What is the position of that money? This NSA amount?
The NSC amount is not handed over to the complainant yet. It is in the office, I guess, right now.
So thereafter, case was registered under 409. Charge sheeted? No, not yet charge.
CR case.
Oh, CR case. Cognizance taken. And what is the procedure now?
Appearance stage.
It is in the
Still in the appearance stage.
It is still in the appearance stage.
Achha. So you are against the cognizance order as well as you want to get the entire criminal proceeding quashed. Yes, that is the main issue. And any other submission from your side?
That is the main issue.
So as per you now in the present circumstances, 407 is not attractive against her.
Yes, 409 is not applicable against her because she was being transferred and promoted. She was no longer in that post. How can she be held liable? She has done her duty when she was in that post. A new sub postmaster was appointed, so he has to conduct his duty. So he went through his process and procedure. So assuming that the earlier sub postmaster had committed some crime, so 409.
No, question will be whom is appropriated.
The NSC amount is not that much. It is of 1,000 and 1,000.
2,000.
2,000 rupees.
So your petitioner has already
4,000
spent more than
4,000. So if the complainant comes to the post office and take his NSC encashment amount, so the case might get settled.
Get that settlement then. Otherwise, you can go.
The case is proceeding before the trial court lordship. So, and the next date is fixed on 9/5/2025. And if your lordship wants to hear this case in further details, there was a order in the motion date. So after the appearance of the respondent, there will be interim granted to stay the proceedings of the
No,
trial
but
court.
we are finally hearing now.
Okay.
It is as it is in admission stage, no further hearing. Yes.
Lordship, my preliminary objection would be, Lordship. Lordship, may kindly come to page number 3 of their petition. This application is filed under section 438/442 of the BNSS. 438, Lordship, is calling for records to exercise powers of revision. Now, Lordship, against the order of cognizance, Lordship, issuance of someone, they had preferred one revision petition before the learned session court. That was
Already?
dismissed. Yes, that was dismissed. Now, Lordship, if we go by section 438, subsection 3, may I read it, Lordship?
Yes.
If an application under this section has been made by any person, either to the High Court or to the Sessions Judge, no further application by the same person shall be entertained by other of them. Number one, Lordship. This is my.
What you have said, 438, yes, I am not just.
Oh, I'm sorry, Lordship. 438, subsection 3. Their revision petition by the Sessions Judge dismissed. Subsection 3 says, if an application under this section has been made by any person, either to the High Court or to the Sessions Judge, no further application by the same person shall be entertained by other of them. This is one, Lordship. 438, they have filed once again. Now, Lordship, may kindly come to the prayer portion. Prayer portion, Lordship. So this petition is, Lordship, not maintainable. They cannot file, Lordship, the second revision petition. There is a embargo, Lordship, provided by section 438, subsection 3. Second submission would be, Lordship, my learned friend has submitted that, Lordship, they have preferred this petition for quashing the entire process. If we go by the prayer portion, Lordship, their only prayer is that, Lordship, the impugned order dated 17/7/2023, my Lord, may kindly come to page number 9. In the premises, it is therefore prayed that your Lordship would graciously be pleased enough to admit this petition, call for records, issue notice to the opposite party to show cause as to why the impugned order dated so-and-so, passed in CR case number so-and-so, passed by the learned judicial magistrate first class, and order dated 1/7/2024, passed by the learned additional sessions judge in revision petition number 45 of 2023, and CR case number so-and-so, so-and-so, pending before the so-and-so, 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 as a whole should not be set aside and quashed. So, Lordship, they have prayed for quashing of the revision petitions order, Lordship, by way of another revision petition, which is, Lordship, not permissible as per section 438, subsection 3. And, Lordship, the ground, Lordship, which they have taken, Lordship, in the entire petition, their prime ground is that, Lordship, while taking cognizance, the learned magistrate has failed to assign the reason as to why the process has been initiated. Now, Lordship, may kindly come to the order, Lordship, at page number 20.
Animal matter. Last. Yes.
Page number 20. Page number 20.
20.
20, Lordship. Order dated 17/7/2023. Today the case is fixed for
A further inquiry of witnesses. Complainant is present along with one witness. Statement of the witness has been recorded on oath under section 202 of CRPC. Heard. Peruse the case record. Prima facie incriminating material under section 409 IPC is established against the accused person, namely Alpana Dasgupta, that is the petitioner, and accordingly cognizance is taken against him under section 409 of IPC. Issue summons upon the aforementioned accused person. This is the order, Lordship, which has been passed, Lordship. In the entire petition, Lordship, they have stated that, Lordship, there is no reason assigned by the magistrate as to why, Lordship, cognizance has been taken. Therefore, this order is back, they have said. Now, Lordship may kindly come to the order passed by the learned additional sessions, as Lordship. Lordship may kindly take up the additional affidavit. Written objection, Lordship. We have filed the written objection. Page number 30.
Yes.
Page number 30, Lordship. This is the revision order passed by the divisional court, Lordship. Whereby Lordship may kindly come to the last paragraph, Lordship. Paragraph number 13. Page number 41. Paragraph number 13, my lord. The learned magistrate has held that in the impugned order that peruse the case record, prima facie incriminating material under section 409 established against the accused person, namely Alpana Dasgupta, and accordingly cognizance is taken against him under section 409 IPC. In the light of the above discussion, more particularly the decision of the Honorable Supreme Court in Jagdish Ram versus so and so reported in so and so, wherein it was held that taking cognizance is the exclusive domain of the magistrate, and at that stage the satisfaction is to be arrived at is whether there is sufficient ground to proceed and not for conviction, as it can be determined only at the trial and not at the stage of inquiry. Honorable Supreme Court also held that at the stage of issuing of process to the accused, the magistrate is not required to record the reasons. Summarizing the above discussion, it is found that impugned order dated 17/7/2023 passed by the learned magistrate doesn't suffer from any illegality and needs no interference and is upheld. Now, Lordship, in support of my submission that order dated 17/7/2023, there is reason. The learned magistrate has clearly applied his mind, specifically mentioned that prima facie incriminating material under section 409 is there against the petitioner. Now, whether detailed order is required or not, Lordship, I'm going to rely on certain decisions. My lord, may kindly take up the first case, Lordship, 1976 3 SCC 736.
You rely on which para?
Relying on, Lordship, paragraph number 6, Lordship. To kindly permit me to read the paragraph number 4 before that, Lordship. That would be convenient. It would be thus be clear from two decisions of this court that the scope of inquiry under section 202 of the Code of Criminal Procedure is extremely limited only to ascertainment of to the truth or falsehood of the allegation made in the complaint. Number one, on the materials placed by the complainant before the court. Number two, for the limited purpose of finding out whether prima facie case for issuance of process has been made out. Number three, for deciding the question purely from the point of view of the complainant without at all adverting to any that the accused may have, any defense that the accused may have. In fact, it is well settled that in a proceedings under section 202, the accused has got absolutely no locus standi and is not entitled to be heard on the question whether the process should be issued against him or not. Now, Lordship may kindly come to paragraph number 6. It's a long paragraph, Lordship. I'm just reading the last part, Lordship. Last page, Lordship. Eighteen lines from the top, Lordship. In fact, page number 742. In fact, my lord got it.
Yes.
In fact, the magistrate considering the question as to whether process should be issued against the accused or not cannot go into the materials placed by the accused, and therefore the High Court could not have given any such direction while disposing of the previous revision. The imprint order of the High Court proceeds on the basis that it was incumbent on the magistrate to have considered the documents and their effect on the truth or falsehood of the allegations made by the complainant. This was an entirely wrong approach, as we are clearly of the opinion that the magistrate was fully justified in completely excluding the documents from consideration. We refrain from making any observation regarding the effect of those documents. In fact, the document filed by the respondents were mere copies and they were not so and so. At any rate, at the stage of section 202 or section 204 of the Code of Criminal Procedure, as the accused had no locus standi, the magistrate may be produced by the accused who could be present only to watch the proceeding and not to participate in them. Indeed, if the documents or evidence produced by so and so is allowed to be taken, magistrate then an inquiry under section so and so would have to be converted into a full dress trial, defeating the very object for which this section has been effected, the High Court in so and so. Now, Lordship, thereafter in the subsequent two judgments, Lordship, just now I have given, Lordship, I will read only one paragraph from the judgment of Bhushan Kumar, Lordship, 2012, 5 SCC 424. Paragraph number 12, 13, and 14. Page number 429, my lord. Paragraph number 13. Paragraph number 12, Lordship, someone has been described. Paragraph number 13, I am reading, Lordship. Section 204 of the Code does not mandate the magistrate to explicitly state the reasons for issuance of summons. It clearly states that if, in the opinion of a magistrate taking cognizance of an offense, there is sufficient grounds for proceeding, then the summons may be issued. This section mandates the magistrate to form an opinion as to whether there exists a sufficient ground for summons to be issued, but it is nowhere mentioned in this section that explicit narration of the same is mandatory, meaning thereby that it is not a prerequisite for deciding the validity of summons issued. Time and again, it has been stated by this court that summoning order under section 204 of the court requires no explicit reason to be stated because it is imperative that the magistrate must have taken notice of the acquisition and applied his mind to the allegation made in the so and so materials and therewith. My lord, in the next judgment, Lordship, the line and length more or less same, Lordship. I am relying on paragraph number 65 and 66. And 66. I'm not reading those paragraphs for the power. And Lordship, another very recent judgment, Lordship. only paragraph number 17, Lordship. Paragraph number 17, Lordship. Page number 10. Section 204 of the code does not mandate the magistrate to explicitly state the reasons for issuance of summons, and that is not a prerequisite for deciding the validity of summons. Nevertheless, the requirement of the code is that the summons is same thing. Lordship has been once again, Lordship has been said here, Lordship. Even Lordship, the decision, Lordship, of Bhushan Kumar, the 2012 judgment has been referred here, Lordship. 1976 judgment also has been referred, Lordship. So therefore, Lordship, the ground on which they have challenged the entire proceedings, Lordship, if we peruse the entire petition, Lordship, the only ground is that there is no ground, no reason of the order, Lordship, which has been passed by the magistrate, it is not a reasoned order. Therefore, it has to be set aside, the entire proceedings has to go. My submission is that the order dated 17/7/2023 is a reasoned order. Magistrate has applied its mind. The revisional court has also relied on, by relying on certain judgment of the Honorable Apex Court, passed a detailed order. Therefore, Lordship, no interference is required. My humble submission is that one. And Lordship, so far as my preliminary objection, Lordship, that would be clear, 438.
Yes.
That's all, Lordship. I raise my case.
It's a downward matter now. Delivery of order of my activity. Next turn. Next turn. No. He did already. I'm keeping it for delivery of order on foot.
Lordship, in this case, though I have argued, let my senior be heard once. He is in court number 14, I guess.
No, we are rising.
No, not now. Some other date maybe.
No,
Just one date.
It's not possible. Now he has come already. Being on the same prayer, this is just not proper also, no? Why are we arguing this matter?
It's a mistake in the cost title, I admit that. And I would go to the petition, Lordship, where the petitioner, that is page 16. There is that the complainant repeatedly visited the sub-post office, Patharkandi, and being directed by the sub-postmaster Patharkandi, signed some forms, papers to get manual payment in his account, but regret to say that eventually he did not get any payment. Rather, sub-postmaster Patharkandi, SO, failed to divulge the reason behind the non-payment of the said certificates. That was stated in his petition, that is para number 4.
You see, the question is that your entire petition
Yes.
is based on, as you have submitted, based on the fact that, and the issue that the cognizance which have been taken by the learned magistrate is not reasonable one, without any justifying reasons, without paying any reasons, that has been cognizance has been taken. So only against that order, you have already moved an application, revision before the learned session judge.
Yes.
After dismissal of the petition, same, you have again approached this court with the
No,
same reason
This
petition.
one I admit this is
That
a mistake.
Mm.
This is totally a mistake in the cost title. I beg apology for that. It has to go for the criminal quashing. It has to be 528, but it is wrongly mentioned as revision petition. That is a mistake in the cost title. I admit that. But
That case is registered as criminal petition, otherwise.
Otherwise, it is registered as criminal petition. But there is a mistake committed in the matter of
Is registered as a criminal petition.
criminal petition. That's why in the prayer we have prayed for quashing of the entire proceeding. And my another submission is that the petitioner, she is no longer in that post. After 18, I think there is a date. That is page number 18, annexure 3. The deposition of the complainant. There, the complainant stated, thereafter on 18/8/2022, the sub-postmaster Pathakandi sent a letter to the superintendent of posts, Kachar division seizure, for sanction of manual payment. Even then, I did not get my money back. After 18/8/2022, the present petitioner was being transferred. So whether the present petitioner can be held liable for 409?
That you have submitted, yes. Yes, and you
Anything
have,
should I aid to her?
Yes,
I don't
yes,
know what she has submitted. I am hopeful that she has done everything. I was settling in three courts, my lord, 9, 14 and your court. My lord, I do not know why there's a small matter, my lord. They are now, to my information, yesterday I had deliberated with the postmaster. That she is not coming. We are asking her to come and take back your money. A small amount, fixed deposit was there. But she is bad about the person to punish him under 409. How 409 will be helpful to this man? She is no longer in service also that post now.
otherwise, your petitioner can approach there if they are ready.
No, nothing to approach. My lord. If your lordship give me direction, I'll send the money to her house. But she have to sign some document. That is the problem. Postal department, your lordship knows there are so many formalities. Just the
They are
harassing.
basically stressing on the point that when she was posted as a postmaster, sorry, at that time these things had happened and she took initiative writing letters to the higher authority for regarding the payment and whatever.
Manual payment.
Manual payment. But subsequently she got transferred and now posted it somewhere else after the promotion. So that's why now their submission is how she can be liable for 409. One. Number two, they're saying that till now they're definitely ready to make your payment because everything is ready. If you come once to the post office, then it will be paid. In that context, you can make a try. I don't know, but yes, criminality will never vanish. That is just there. What is criminally liable? That will be there. But if some development is there, otherwise, I don't know what to do. It's up to you. I can otherwise we'll pass the order. Yes, any further.
Well, so far as the issue is concerned, Lordship, definitely Lordship, my learned friend will have a talk with the client, Lordship. But otherwise, Lordship, as to whether section 409 will be there, Lordship, that I can reply, Lordship. As because, Lordship, I have already submitted on merit, Lordship. The order of the learned court will, as well as the order of the revisional court is there, Lordship. Those things will be there, Lordship. But yes, if Lordship, considering the amount, Lordship, 4,000, then Lordship, I have some limitations, Lordship.
Why you are want to harass a lady who is to now attend every month into the court?
And Lordship, if Lordship, that is the submission, Lordship, my reply would be, Lordship, the petition, why the petitioner has approached the court.
Then that's why I have to approach.
The opposite party had to approach the court at that point of time. Whether that was not harassment. Now, Lordship, kindly see, these things started in the year 2022. They have issued this letter in the year 2023 saying that your payment is ready. This is the letter, page number 23, where only 2 numbers of NSC has been given. These 2 are ready. Other 2, where the other 2 has gone. Lordship, harassing, if the question is harassing, then Lordship, I would submit that Lordship may dispose of this petition on merit.
Okay. There's any other submission?
My lord, I think page 23, it has been mentioned that 3 certificates, all are 2 certificates. We have already ready to give her. But if I think my lord, if a bank manager suppose refuse to pay the amount, then because there are some technical problem, I have to take sanction. And can there be a case 409? Next day is coming and money is being paid. Yeah, we are asking him to come and take the money, your certificate. And the innocent lady, she has got no control over the matter. Because as per the formula, they have to, for manual payment, they have to write to the superintendent of post offices at Silchar. That is the superintendent office.
Okay, Mr. Ahmed, do one thing then. Obviously, there are 2-3 points which have already raised regarding the maintainability or the order passed, cognizance taken, so and so. These are there, the judgments are also there. But the question, if the matter is that she is already initiated the process and the those things got transferred and now it is ready. So it's up to you. We may give you a date in that case.
If that is what Lordship I said, Lordship. But certainly, Lordship, the submission was that we are harassing the petitioner. That is good.
That is not. Then do one thing. Otherwise, I have recorded everything from your side and submissions are also there. So I won't keep it as a part heard because part heard may create another problem.
Yes, ma'am.
So I'm just giving you a date. Just let us know what is the recent development.
Yes.
If your client is already satisfied, there may not be suppose in the long run, but yes, but the question is just 409 is there. 409 is a very, serious nature of offense because 409 is a misappropriation some government
fund.
She is a government employee, semi-government employee. So it's a very serious allegation. Otherwise, it's not at all compoundable or on the basis of which cannot be compounded or petition cannot be quashed. That is one of the aspect also there. We'll give you time till 1 week, 2 week, or otherwise I will dispose the matter because I'm fixing a date on Wednesday for delivery of order.
And moreover, he will get with all interest till today, because it is with the government, post office. Up to the interest also he will get.
Yes, what to do? Just tell us.
Yes, Lordship may kindly give us some time so that we can have a talk with our client, Lordship, considering the interest of the petitioner also, Lordship, they are really good. But otherwise, Lordship, harassment was from both the sides, Lordship.
So you are doing it.
Obviously, that can be understood.
Next week?
Next week, we don't have any date.
Then I'll leave it to as per your accommodation money.
He also, you talk to her next week, prior before we are not, it's not possible.
You will be after before
22nd, any date, Lordship, in that week, Lordship, 22 to 25, 21 to 20.
25 can be given.
Yes.
25 for.
But till then, further proceeding may
Lordship,
kindly be
Lordship,
stayed.
I have objection.
Stay will not be there. 25 for at best. Today, rather the petition was come up, we could have disposed of the matter today. But as you have raised the question that everything is ready, they can come and take the benefit. The money.
The whole story. We have been asking them. They have also taken challenge.
Your as per Ms. Bora submitted that the matter has been fixed on
9/5.
9/5. So prior 9/5, we are fixing it on 25/5. If there is any development, he will let us know and will dispose of the matter accordingly.
Just keeping this as part heard.
কি করি পাঠার করে দিবি
Let it be part heard.
Otherwise,
we want it to be part heard.
Part heard, yes, obviously, but part heard also creates some problem. In fact,
Yes,
sometimes the benches may not be available. That is the main issue.
Anyway,
I have already consumed more than 40 minutes.
Yes.
Better. It should remain part heard.
The part heard going to fix 25 for. Oh. Mrs. Oh.